The 37th Circuit Court is now in session with the Honorable Ryan K. Kirkham presiding. It is Wednesday, April 3rd, 2024 at 1:31 p.m. And this is case 2023-1344 DC, Porter Ward versus Daniel Newbern, Attorney Storm for plaintiff and Attorney Ives for defendant.
Good afternoon to everyone.
Good afternoon.
Good afternoon.
Look back and you can correct me if I'm wrong. I think when we adjourned last week that Ms. Storm, you were on your recross of the defendant. Is that correct?
Correct.
Okay. Ms. Newbern, you're still under oath, okay?
Yes, sir.
Okay, go ahead, Ms. Storm.
Ms. Newbern, in your testimony last time we were here, you indicated that Porter had gotten physical with you. What is your definition of physical?
I was backed into a wall in that particular time.
Okay. Did he actually ever put his hands on you?
No, his hands were on the walls next to me.
Okay. So you consider yelling and getting in someone's face physical then?
Slightly, yeah.
Okay.
Yes.
If that's the case, isn't it fair to say that you get physical with Porter as well because you yell and do the same back?
I have never gotten in Porter's face, no.
Okay. The night that the two of you broke up, wasn't it true that you in fact didn't come home right after work that night and didn't end up getting to the house until about 5 a.m.?
That's not true at all.
What time did you get home?
I left about, I want to say 9, so I got there about 9:15, 9:20.
Okay. At this point, isn't Demetrius in bed?
At that time, no, he was not.
Okay. You stated that Porter belittles you and he makes you feel like you can't afford things, but when has my client ever said something about money to you or not being able to afford things?
Several times when we first broke up and I needed a little bit of help, as well as when he was paying for my car right before he stopped.
Okay, but that hasn't happened recently, has it then?
In the last couple months, no.
Well, you said that was right when you guys broke up. That was 3 years ago, right?
Yeah, but he stopped paying for my car in the middle of last year.
Okay, so even though the two of you were broken up, he was still paying for your car?
He was helping me pay on my car, yes.
Okay.
And I was helping him pay on his bike.
Okay. Now, do you ever just DJ at the Vegas strip club?
I only DJ at the Vegas strip club.
Okay. Is it true that the dancers have to tip you out there to play their songs?
No, it is not. We had a lawsuit a couple years ago and we changed our contract so they are no longer like forced to tip. They tip if they feel like it, and a lot of them don't.
Okay. Have you ever been asked to cover or been called in to the Vegas strip club or the dude?
Yes.
Okay.
Both.
Did you ask Porter to watch Demetrius during those times?
No, because I normally don't have him on the times that I get called in.
Okay. Then 1 second. Direct your attention to what had been labeled as our proposed exhibit 18 and look at page 39 to refresh your memory.
1 second.
You said 18?
Page 39 of 18 of the exhibit 18, yes. Pages 39 and 40 are printed on the same page.
Oh, yeah. April of last year, I asked him to keep him on a Sunday.
Okay. Because you had to work at Vegas, correct?
Yes, I did forget that. I'm sorry.
Okay. And I'll have you also look at page 141. Did you find that page?
Yes. That's me asking if he wanted to swap because of my birthday.
Okay. And it also actually, doesn't that first line say something different?
DJ asked me to work tomorrow, and since next week is my birthday, I thought I'd ask.
Okay. And when did that text message go through?
February 6th.
Of this year?
Yes.
I'd like you to turn that to 143.
It says, do you want to swap Wednesday? DJ asked me to work tomorrow. And since next week is my birthday, I thought I'd ask. It's fine if not. I'm sorry, I can't hear you.
On page 143, it says that.
Oh, I didn't hear the next page. I'm sorry.
Yep. So now I'm looking at page 143.
Okay, it says that I will get him, or it asks if he wants to get him because Demetrius asked. And then he asked me if I was working and I asked if we were switching.
Okay. And were you working?
That night,
Yes.
I went in really late after I put him to sleep.
So there have been multiple times you've asked Porter to watch Demetrius for you while you've been working, correct?
Yes.
Now you stated that you contacted Porter and told him about the new job. Are you sure that's how the conversation went?
I'm not understanding.
You testified that you told Porter in advance about your new job.
I told him that I would be getting a new job, yes.
Okay. I want you to take a look at page 113. Is that a conversation between you and Porter about your new job?
And I said, I only work Monday until 4. He said, did you start a new job? I said, yes, why?
And he said that, what was his response to that?
Just curious, as normally you work all week, so what time will you be picking him up at? And then he said, where are you working now? And I
And
said,
what
I'm
was
in
your
town, I
response?
work at a dispensary.
Okay, why didn't you just tell him the name of the dispensary?
Because I didn't think it was important.
So you didn't actually tell Porter you got a new job. He actually confronted you and asked you whether you had a new job.
Actually, when I applied for that job, I told Porter I might be switching jobs because I was looking for something new, which is why I said that I told him I would be getting a new job. I just
Do you have a
didn't
text message to show that?
know because that was an in-person conversation.
Okay.
It was something that was said in passing while swapping.
Okay. But the fact is that you said that you told Porter that you got a new job when you hadn't. That wasn't how it actually happened, correct?
I did not tell him as soon as I got the new job, no.
Okay. He had to hear it and find it out through someone or figure it out on his own, essentially, and ask you about
Yes.
it. Okay. Prior to June of 2023, weren't you working 40 hours a week?
No, I was working closer to 35 to 38 unless I picked up shifts.
Okay. And you'd get out around 5 p.m. at the Dude?
Yes.
Okay. And you've switched around your schedule now so that you're working less than the 35 to 38 hours?
No, I still work 35 hours or so, but the schedule switched because of our staffing.
Okay. So now you have the ability to get Demetrius to school at whatever time at this point?
I wouldn't say whatever time. I still have to get into work by a specific time.
And what time is that?
8 45.
Okay. Um. I'd like you to take a look. I'm gonna ask you about January 2024, because we are talking about denied parenting time. On the 16th and 17th of January of this year, did Demetrius have school to your knowledge?
I want to say those were snow days.
Okay. Uh, did you send him to his father's house while you were at work on those days?
No, well, one of them, I believe I was off. I'd have to double check, but the second one, I know for a fact he stayed with my grandmother and my cousin because he called them and told them that's where he wanted to be.
I'd ask the court to strike any hearsay.
Ms. Ives, any response?
I guess, this is when, you can't talk about what your son said. Your Honor, I'll just let you make a ruling.
I'll sustain if she's saying what the child said. You can't testify as to what the child says.
Okay. So moving forward, did Demetrius then have school on January 23rd?
Again, I would have to double check, but it was probably another snow day because that January was a lot of snow days.
Okay. I'm gonna direct you to look at pages 137 and 138 of Exhibit 18.
Oh, I dropped him at the Montessori school that day.
Okay. Now, isn't it true though that you denied Porter his parenting time that day?
Oh no, yeah, that was not denied parenting time.
This was January of this year, correct?
Yes.
And this was after the interim order regarding the time on Monday, Tuesdays, and alternating Wednesdays that Porter should have had that was in place, correct?
That was a Tuesday, actually.
That's not the question I'm asking.
Well, I think
The question is, do you remember the temporary order?
yes, in which I got my days, Monday, Tuesday, and alternating Wednesdays. That was a Tuesday.
No, the interim order says that on Mondays, Tuesdays, and alternating Wednesdays, that Porter is able to have that after school time. There was no school those days, and I'm asking you, did Porter have Demetrius at all during that day? Either of those days?
I do not believe he picked him up, no.
Okay, because there was no school. There was nothing to actually pick him up from, correct?
No, there was no school to pick him up from.
Okay, so you couldn't have dropped him off at Battle Creek Montessori because there was no school that day.
No, that was the other day. I apologize.
Okay.
I was in the middle of reading, but I was available for that day. So
And yet, so you're still going beyond what my questions are asking. So my question then is, you want right of first refusal regarding daycare, correct?
regarding childcare, yes.
Okay, but you don't offer this to Porter at any point prior to any of this. You've never offered that.
I would disagree with that.
You've rarely offered that.
I would agree with rarely, but to say never would be untrue.
And so all these times where your grandma or cousin could have been watching him, Porter could have watched him, correct?
Yes, and I asked for some of them, and for some of them, I have conversations that lead me to believe that he should be home than he was there.
Okay. But that's not what's reflected in these text messages, is it?
And this particular conversation,
In any of the conversations I've pointed out in Exhibit 18, that spans the entirety of, let's see, starting with,
well, in
I'm
some,
going to
let me
object.
finish, just let me finish. Starting with February 5th of 2023. February 11th of 2024, so an entire year of text messages
I can't hear
between
you.
Sorry, so an entire year of text message conversations because it was February of 23 to February of 24.
I'm going to object to the question because the objection calls for a very expansive answer. And this exhibit is 146 pages long, and it covers conversations that include many, many topics. And so that the question is just unanswerable, Your Honor.
I believe it's not unanswerable, Your Honor. In fact, these have been given to Ms. Ives and Ms. Newbern since our first hearing on this just over a month ago now at this point, and over in March. So we're in 3 weeks now, roughly. She's had it since that time, and they were objected to being admitted as exhibits because she said she hadn't had time to review them. She's had plenty of time in the time since then to review them, and it's within my right to use these proposed exhibits, even though they're not exhibits, to use them to refresh Ms. Newbern's testimony or memory and to show that honestly, she's not being truthful with her testimony, not
Well,
today and not other days.
the court is going to allow specific questions as it relates to those documents, but I'm not going to, again, extrapolate a generalization from those. So if you have specific questions, ask the specific questions.
Thank you. So earlier you testified that you give Porter right of first refusal and you want that reciprocated. But isn't it true that you don't do that very often?
I do not do that very often, yes.
Okay, why do you think that right of first refusal can work if that's not something you were willing to do prior?
Because we see in those text messages where I ask him, instead of just straight going to my grandmother every single time, I do offer it. Even before that, it was offered where I'd be like, hey, do you want to switch a day?
I'm going to say that contradicts with the testimony you just provided, because you just said that you don't give him that notice very often. And my question was, why would right of first refusal work now? Why are we believing that you would offer this now when history shows us that you don't do that? And your testimony today was that you rarely do it.
Because I rarely need it. But if I need it and that is the thing that's in place and it would be easier, it is always in Demetrius's best interest to be with one of his parents. And I do believe.
So on January 23rd, then, rather than just allowing Demetrius to be with dad, you thought it was more appropriate to be with grandma and cousin?
I could, yes, I did.
Okay. Now, didn't Porter offer to come and get Demetrius from you since you said you were concerned to drive about driving due to not having good tires?
That is true.
Did you take Porter up on that offer?
I told Porter that he could go get him, as well as I told my grandmother that if that's where, or if Demetrius wanted to go with him, that's where he would go.
Actually, I'd like to have you refer back to page 137, looking at the 4th and 5th, excuse me, 4th text message from the bottom from you on January 23rd, 2024.
Okay.
And what did that message from you to him say?
It says, actually, he's been obsessed with a work booklet. He won't be dressed because I'm not waking him up when he doesn't need to be outside in this. My cousins are here to help watch him. You wouldn't even be who he's with. It would be Alicia, and the roads were clear yesterday. Nice try.
Okay. And then the very last one on the page is your message offering time. Why don't you read that one?
If you would like to get him at 3 and bring him back at 5, you are welcome to do that.
Why'd you only offer 2 hours of parenting time from 3 until 5?
Because he had said something about our parenting time, about his parenting time being denied. And I said it wasn't being denied. And then when I went back and looked at the order that we had, he got after school privileges. And I was like, you know what? He can do his after school stuff. He gets 2 hours on my days normally. I had sat and I thought about it. I read over the thing and I was like, in order to keep myself from getting in trouble, because I was not trying to do anything wrong, those 2 hours were.
I'm going to read this for you. If you'd like to get him at 3 and bring him back at 5, you are welcome to do that. But the words are supposed to get worse and worse. I'm assuming you mean roads.
Yes.
He then responded, what's the difference between me picking him up now and then, other than, as you say, the roads are getting worse? It's an excuse to keep me from having him. This is all sent at 7:45 in the morning, correct?
Yes.
So plenty of time to have done this exchange earlier than 5, or than 3,
Actually,
excuse me.
I was already out of the house at that time. I left early because, as I said, my tires are summer tires and not winter tires.
I need you to answer the questions I'm asking rather than interjecting, because we do have a limited time here and I have a lot to go through with you. Doesn't it say that you respond, LMAO, Porter, contrary to your belief, I don't think about you. I don't do anything with keeping him from you in mind. He is sleeping at the moment and I'm not here to wake him up and get him dressed. Around 3, he'll be up. Trevor will have fed and dressed. So at
Yes.
7:45 in the morning until 3, you couldn't guarantee when he would be up and dressed until 3 o'clock?
That might seem what it sounded like, but I just meant that at 3, he would for sure have all of those things done.
Okay. Well, again, you know what? I'll retract that. Since then, have you gotten new tires?
No, stop snowing and things like that.
But weren't there issues on the 16th also with weather? Excuse me, January 16th for the context, for the record. And you dropped Demetrius off in the morning that time without issue when there was weather.
The roads were nowhere near as bad.
Okay. Were you aware that Demetrius was actually FaceTiming Alicia during the time that you were texting Porter and therefore was not asleep?
I was after my cousin called me, yes.
Okay. The question, on New Year's Eve in 2023 into 2024, that was your holiday to have Demetrius, correct?
Yes.
Now,
believe
were
so.
you in fact working that night at the Vegas Strip?
New Year's Eve itself, yes.
Okay. And Demetrius was left with your grandmother during that time?
My grandmother and my cousin, yes.
Okay. So that was another time. Did you ever check with Porter to see if he wanted to have New Year's Eve since you were working?
That time, no, not that I recall.
Okay. Do you deny that you removed Porter completely from the daycare at Bright Lights?
I did not put his name on the information when I renewed it. No, I did not.
Would you like the same done to you if Porter was in that situation?
The same has been done to me.
The question
And
though
no, I
is,
did not
would you
like
like
it.
it? Thank you.
No, I did not like it.
Thank
But
you. I'm good. Thank you. So At that time when you removed him off of your account, did you tell the daycare, or did the daycare make it clear to you that you would then have to give permission every time for Porter to pick up Demetrius from daycare?
It wasn't said in that way, but I knew that he would have to have permission, and I knew that they knew he had permission because he is his dad.
So why not even include Porter on your re-registration?
Because I did not want him on my account any longer. He was using it as a way to screenshot and send it to me to tell me what time I was doing things when that wasn't accurate. The time that I logged Demetrius in was not what time we got there.
So the records at Bright Light were then wrong that he was looking at, that they weren't keeping accurate times of when you were getting there?
Seeing as how the parents logged the children in, it was about a 5 to 10 minute grace period. Most of the time I would log him in on my way out, and I would stop in and I would talk to teachers for a little bit and then I would leave. So no, it wasn't completely accurate.
Didn't you and Porter have a conversation about you removing him from the daycare on or about July 8th of 2023?
I would have to refresh my memory, but I'm assuming that is the conversation in which I told him that he could still get the stuff. He just had to make his own account.
Okay. Did you tell Porter that's what had actually happened?
Uh, I'm not entirely sure on how that conversation went, if we're being honest. That was an argument.
At that time, didn't you tell Porter that you had changed your work schedule so that you would be getting Demetrius some daycare so that Porter wouldn't need to or be able to anymore?
Again, I'd have to check, but I don't believe it was said that way. I did tell him that I would not need him to get him though.
Okay, I'll have you return to page 70 to refresh your memory.
17 or
Seven-
70?
70.
Okay, that says that I worked it out with my job that I can get him because I was
Again,
getting
I'm
ready
not
for the
asking you to read that section. I'd like you to actually refresh your memory first. Does my client ask you for a schedule for you?
Yes.
Does he ask you what's going on with daycare? I'm specifically looking at that very first message, page 70.
I was reading through it.
That's where he lets you know that he no longer has access, correct?
Yes.
And then you respond that you've worked it out with your job so that you can pick him up from school on your days, and that you want to be ready for when school year starts, and that Porter can still pick him up if need be or asked to, that you just have to give the daycare a heads up, right?
Mm-hmm.
And Porter asked you about changing the routine that you guys have been following, and your response is, Not necessarily. Anytime I've been able to get him from school, I do. I'm just able to do it more now. Is that correct?
Yes.
Okay. But isn't it true then that my client responds that you've not gotten him to school or him from school, but on any of your days off, that my client has done that every day since you started, and that you'd only let him get him on a Monday or Tuesday when you had a random day off?
Yes, that is what it says.
Okay. Okay.
But it also says that I've been able to get him from school. Before the text message before that, I say that I have been able to on my days off. So he just reiterated what I had already said by saying, no, I didn't. He only got him when I didn't have days, you know.
And those were rare, correct?
They were kind of, but not really. No.
So didn't Porter express concerns about changing Demetrius's routine?
He did.
Did you respond or have any concerns yourself?
Um, and this manuscript, it doesn't look like I said anything to his concerns, but I did speak to Demetrius. Not that I can like give anything on that conversation, but
You want to
I
go
did
on to page 71 to keep refreshing your memory where the conversation continues? Isn't it true that my client, after having, if you refresh your memory, isn't it true that my client routinely had Demetrius after school or daycare until 6 o'clock or so when you would be done with work, except for the rare times that you had a day off?
yes.
Okay. Did you think that you changing your work schedule to pick up Demetrius earlier and to prevent that time would have any impact on Demetrius, changing that schedule?
I thought it would make him happier to see me, but that was about it.
Okay. Did you think about whether it would impact him at all to be sad to not see his dad as much?
I did not.
Okay. And in that very first message on page 71, don't you tell him that you,
I
because
can't
he's
hear
taking, sorry, that because he's taking him to Battle Creek, for daycare on Thursday and Friday, that therefore, why don't you just read that first paragraph, that first message you sent on top of page 71?
Um, as of right now, you do not have access to the account I pay for that gives access to the key fob, nor do you have a password to check in or out. You said you're taking him to a different school on your days, so when I read his paperwork or redid his paperwork, I did not put you on it besides an emergency contact.
So why would Porter wanting him to go to a different school, daycare during the summer, mean it was okay to take him off of the contact other than an emergency contact?
Because the only reason he was on my account in and of itself was because he was picking him up from there. But if he was no longer going to be picking him up from there and only using that account to berate me, then there was no need for him to be on it.
But he actually was picking Demetrius up, wasn't he? On your days?
He wasn't going to be. I was going to be.
But the actuality, the fact is that Porter still picked him up on those days, correct?
Yes.
Okay. And you were informed that the summer program had a fee and that you had to continue to pay, correct?
Yes.
And there was a free option available?
For the summer program, not
Yes.
that I was aware of. The schooling itself, yes, but the summer program we had to pay for.
Okay. Do you remember the cost difference between where he was and the new one?
I paid $215 a week. I'm not entirely sure. I think it was like $240, $250 for the Montessori one.
If
I
I
could be
told you
wrong.
that it was about $525 total per month, would that refresh your memory?
It would tell me, but it wouldn't refresh my memory necessarily.
Okay. So you were faced with choosing to pay $215 a week or splitting the cost of a monthly amount, correct?
As far as I knew, I don't remember talking about splitting anything. I was
Okay.
going based off of the fact that I had been paying for things and I was going to continue to pay for things.
Okay. Did you in fact tell Porter that you were going to choose what works best for you and Demetrius and what the two of you have going on?
I would definitely have to go back and look at text messages on that one. Could you tell me what page?
Absolutely, page 56.
Thank you.
Specifically, it's at the very top of page 56. Did that refresh your memory?
Yes.
Okay. So you did in fact tell him that you're going to choose what works best for us and him, what him and I have going on?
Yes, I did.
Okay. If Porter said that back to you, how would you respond?
It would depend on the circumstance.
Okay. I'm going to jump now to the soccer incident that we've talked about before. You said that you tried to contact Alicia.
I called her one time.
Okay. Even though her phone had 0 missed calls and she testified that there was no call or text from you, no missed calls, nothing.
I can't say what was on her phone, but I called one time and it was after biting my cheek for a very long time because I didn't even want to contact her.
Okay. During that incident, did you also hit the windshield of your car and crack the window?
I did not hit it. My phone slipped out of my hand while I was like, I talk with my hands a lot and I was angrily kind of like doing one of these and my phone slipped out of my hand and cracked my windshield. Yes.
So it's your testimony that your phone just slipped out of your hand at a force strong enough to crack your window?
Yeah, I was literally going like this in front of my thing with my hand in my phone in my hand, and it slipped up just the smallest bit. I
Okay.
actually said the same thing, that it's ridiculous, but yes.
All right.
Cracked my phone too.
Did you ever threaten to send your mother to get Demetrius from Porter?
I did say I would send my mom there, yes.
All right. How many times have you done that?
I don't know, maybe 4 or 5.
Now, you said that there was a 3-month waiting period for the eye appointment. When you made it, that it was 3 months out. Was that correct?
Yes.
So why not in those 3 months tell Porter when that eye appointment was going to be?
Porter was informed the same time that I was informed of that initial eye appointment being made, and then nothing else was said about it. I forgot about it until I got the reminder.
Okay. Do you have a text message that you can point to at all that shows that you sent him that?
I do not.
Okay. Now, didn't you in fact tell Porter that the reason he needed glasses was because he had blue eyes and squinted once while reading a book?
That was only part of that conversation, but those were some of the reasons, yes.
Now, I'm going to direct you to page 13, the exhibit.
Okay.
All right, so starting
Yeah, I hear you.
starting at the second message, since the first one doesn't have to do with the conversation, it's a different one. But starting with the second conversation, February 20th of 2023 at 11:50 a.m., can you tell us what is being said in exchange between the two of you?
It says also, can you check who your eye insurance is so we can get Bubba's eyes checked? And he asked if I was gonna send my work schedule. I said, all right, and then he said, as for the bruise, thanks for letting us know. Is there a reason he needs his eyes checked? Most kids don't go there, get their eyes checked until at least kindergarten. They'd do it at school, but I'll look into it. I said, yeah, sorry, I forgot. I'll send it. And he's just been squinting, and blue eyes are known to be more sensitive, so I want to be proactive if we can. He said, not all blue eyes are sensitive. Alicia and Coralina both have blue eyes, and they don't have any issues. I do notice he does that, but it's when he's playing and trying to be sneaky. He doesn't do it when he's reading or working in his workbook at home, but I'll look into it. I said, okay, I just saw him doing it while he's reading Green Eggs and Ham. So since he didn't go to school, I take it we're not getting him, but we would appreciate it if we could keep him this Wednesday, the 22nd, and Sunday, the 26th, and Monday, 27th, and you would get him back Tuesday since we're leaving next week. Said Wednesday is fine because that gives me time to redo his room. Sunday is fine too, but I don't know about Monday. Can I have some time to think on it?
So this is going into something else, but taking a look at that conversation you just read, is there anything else in there mentioned other than the blue eyes and squinting at a book?
And that specific conversation, no.
Okay, so when did you talk about these other issues with him?
The next time that we traded off Demetrius, and I said something again about his eyes.
Okay, so it was orally done.
It normally is.
Don't you think it would be better for you guys to have this sort of thing in writing?
Well, since then I have started to put things in writing, but yes, it would have been better to be in writing. And I've learned from that.
So when Porter asked you, why didn't you tell him then, other than just squinting at a book?
Because I was also doing something else. I was multitasking.
Okay. And when it came to changing doctors to Serial City, when Porter first talked to you, didn't you in fact say you wanted to do research on it?
I did.
And weren't you the one that first mentioned wanting to change doctors?
I did.
So why were you mad at him following through with something you wanted him to do?
Because I was not informed after the fact. Yeah. Until after the fact, sorry. I was informed after the fact. We had talked about it a little bit. I looked into it the slightest bit, but I did get busy. I do work 2 jobs. And I had not heard anything else of it. So to then be told as kind of like it felt like a jab, like because he didn't remember about the eye appointment, he was going, well, since you didn't tell me, I'll let you know that I didn't tell you I did this thing.
Oh, sorry, I'd like you to look at page 34. Last 2 messages on that page. Isn't that a message from you asking Porter how the doctor's appointment went that you knew about?
That I found out about after the fact, yes.
Okay, it doesn't say that in the text messages, though. It just says, "Forgot to ask you, how did the doctor's appointment go?"
Yes.
And he said, "Didn't go."
I can't hear you.
Said didn't go, had to reschedule because I had to take, because otherwise I'd have to take the whole day off. And I have nothing, and they had nothing until August 20th. They said to call for cancellations.
Yes.
Actually, sorry, that was my client sent to you, forgot to ask you how the doctor's appointment went. And then you told him that you didn't go because otherwise you'd have to take the whole day off, correct?
Yes.
Okay. And turning to the next page, page 35, after you said that you had to reschedule and they couldn't get him in until August, don't you then say, "But if it's okay with you, I'd like to find another doctor"?
Yeah, I already said that I was willing to look for a new doctor.
Okay. But then at that point, my client says, "We've had this conversation before. I'd like to start taking him to Serial City," correct?
Yes.
Okay. Did you respond to that?
I don't. It's not in there. I would have to look at my own text messages, but it does
Okay.
not look like I did.
Okay. Isn't it true that your mom has made doctor's appointments for Demetrius in the past for you?
Yes.
Okay. Why your mom and not you or Porter?
Because sometimes my mom, she's one of those parents, if you will, that kind of steps in and takes over for me. She does a lot of things for me.
Do you think that's appropriate when you and Porter are supposed to be co-parenting and doing this together?
Not always.
Porter's not expected to co-parent with your mom. He's expected to co-parent with you, correct?
Very true.
Okay. If you can't do it for whatever reason, Porter should be able to do it, correct?
Yes.
Okay. I'd like to draw your attention to page 44. This is in relation to the eyeglasses appointment that you had made for Demetrius.
Okay.
And at that appointment, this is February 11th, 2023, you told Porter that Demetrius has astigmatism and that you're ordering glasses, correct?
Yes.
Oh, excuse me, that's my client saying that to you, correct?
February.
I'm
That's me
sorry, I
saying
said, you said that. I thought I heard my client say that was him. He said that's May, not February. So I'm sorry. For the record's clarity, May 11th, 2023, not February. And so you said to him that he's got an astigmatism, correct?
Yes.
And then how did my client respond?
Would have been nice to know ahead of time that he had an eye appointment, but that's fine. Did you use my insurance? And I thought you worked today. Are you taking him back to daycare? Also, I did set his wellness appointment at Serial City. Meant to tell you, but forgot.
Okay. So that's notice in advance, correct?
That is the time I was talking about with the jab.
The jab?
Yeah. Where just a little bit earlier, I said it felt like he let me know as a like, well, since I didn't know this, here's this information.
That's not what the message actually says, does it? It says, would it be nice to know ahead of time that he has an eye appointment? That's fine.
Ms. Storm, we're not hearing you. When you either look down
I'm sorry.
or you look to the side, we can't hear you.
My apologies, Your Honor. So his message actually says, would have been nice to know ahead of time that he had an eye appointment, but that's fine. Did you use my insurance? And I thought you worked today. Are you taking him back to daycare? Also, I did set his wellness appointment at Serial City, meant to tell you, but forgot. How is that antagonizing or provoking you?
Because the text messages, the way that they were received in my phone is that text that's underneath it first and then the first one. So just like you and I talked about the last time when we were still in your part of questioning, how the tone of a text message can be misconstrued. The tone felt like an attitude to me because I got that.
But looking at the time marks on those messages are sent 4 minutes apart, aren't they?
Yes, but I was in a building with no service, meaning the way that they came into my phone does not necessarily mean it was the way that they were sent out. It's not the first time we've had text messages do that.
Okay. Okay.
I received those back to back.
You still not want Demetrius to be seen at Serial City at this point?
I've said that if that is where Porter would like to take him, since it's his insurance, that's fine.
Okay. Did Porter tell you why he didn't want Demetrius to attend Fremont?
No, he did not, that I recall. I know he said it didn't matter, that it was just somewhere that I went. We needed to look into more of it.
All right. And even though you knew he didn't want Demetrius to attend there, didn't you communicate to him that he was going to go where you chose, whether he liked it or not?
Something like that, yes.
Okay. Okay. And didn't you tell Porter that you were not going to go back and forth with him with the decision that had already been made, or that Demetrius is a little black boy and would not be going to that racist school?
When we were talking about Gull Lake schools, yes, I did say that he is a little black boy and I did not want him in a school with multiple racist allegations.
Okay.
For
Racist
obvious
allegations
reasons.
that you just heard about, correct?
Yes.
Okay. But you told Porter that you weren't going to even discuss it with him. You weren't going to go back and forth with him anymore about schools.
On that school, yes. I
Okay.
said we could figure it out in court.
Wasn't he also giving you other options at that time, other than Gull Lake or Battle Creek? Montessori, I should say.
The options were Montessori or Gull Lake.
Okay. So my client brings up that, how is Dudley going to work with your work schedule? And you respond that they've got a before and after school program that he can go to, that's free. And my client says, again, this is the first time I'm hearing about this. Kind of hard to co-parent with someone when you do not even involve them in any kind of decisions. When I researched the school, nowhere did it say anything about a before school program. I did see it as the lowest ranking school in the state. The school is not what's best for our son, but you are so stuck on that program, you're making decisions based on that and not based on what.
I can't hear you.
I'm sorry. I'll restart a little bit back.
Okay, go ahead.
That I did see it as the lowest ranking school on the state, but this school is not what's best for our son. But you were so stuck on that program, you're making decisions based on that and not based on what's best for him. Technically, kindergarten doesn't count. It's first grade that does. But if so, exactly when is he getting dropped off in the mornings? I would rather send him to Gull Lake if you are so against Battle Creek Montessori, as they are one of the highest ranking schools. They have a program just like Battle Creek does. Don't you want him to go somewhere where he's going to flourish instead of sending him to one of the worst schools around?
Yes.
Okay. And how did you respond?
I said, be for real, Porter. Your half black son is not going to excel in Gull Lake's racist school district.
And how did my client respond?
You sound super racist right now. You are basing our son's education on race. is also Native American and white, but you don't see me solely making decisions based on that. How would you know they're racist? Have you ever gone there? So you are saying he has to go to an all-black school to excel. Is that what you're saying? You know how ignorant you sound. They have a great education program and are a very blended school. There are many people we know that go there that are half black, and there are kids that are mixed, love it there, and they have not had any issues with race.
Can you continue with the conversation and how you responded and back and forth until that conversation ended?
I said, first of all, don't put words in my mouth. I never said he had to go to an all-black school. Secondly, I'm not basing his education on his race, but his race does matter. He is a little black boy despite your attempts to erase his culture. I want him at Dudley for their school STEM program, which is good. Please stop texting my phone. If you have an issue with something like this, have your lawyer talk to mine, because I don't even feel like I'd be talking to you. And he said, how exactly am I trying to erase his culture? Please give me an example, because not once have I denied he's multi-race. If anything, you are trying to erase his other cultures, and only focusing on one. But right here, you are showing that you refuse to co-parent. I was trying to come up with a compromise, as Kalamazoo schools also have the same program. But if you refuse to co-parent with me and would like these issues directed through our lawyers, that is on you. The school is not teaching him about his culture, so again, I don't see the argument there. He also is not just a black boy despite your attempts. Not once have I said that his race doesn't matter, but he is 5. And I do not want that to be the sole focus, especially pertaining to his education. I want what's best for our son and to have him well-rounded in all his cultures. I said, the only thing I said was I do not agree with him going to a school district with racist rumors floating around. I'm also not going to agree to a school 30 minutes out of the way. As I said, you can talk to my lawyer, because I'm not going back and forth with you via text message about a decision that's already been made. If the judge insists that he must be moved, then fine, but if not, the school he got accepted to is a good school with a curriculum that will keep him engaged. Have a great day.
You believe that Dudley has been picked and that it's up to the judge to decide now excuse me, I'll retract that and say that it's a decision that's already been made where he's going to go to school.
At that time, yes.
Okay. Now, you are also enrolled Demetrius in Fremont recently, or registered him, correct?
I applied. They have a very long waiting list, as well as a application system that you have to get through in order to even be considered.
Okay. But the question that I'm trying to ask you now is, do you realize that that's 30 minutes away from Porter?
Fremont?
Yes.
I did not realize that was 30 minutes away from Porter.
Okay. So why is it okay to not pick a school 30 minutes out of your way, but it's okay to pick a school that's 30 minutes out of Porter's way?
Had I known it was 30 minutes out of Porter's way, I would have revisited that. I was under the impression that it was another 5 minutes from the school he's at now.
You've got
Which it
Porter's
takes me,
address, right?
Porter's address?
Yes.
Besides on the paperwork that I got from you guys, no, I did not have it. I go off muscle memory. I don't have it in my head.
Okay. But you've been there before multiple times?
Yes.
You could have written the address down at any time you were there.
I mean, I guess.
So you could have gotten that information to be able to check a Google search just to see how far of a way it would have been when you were considering Fremont.
Technically, yes, I could have.
Even though also we've talked about in these text messages, knowing that my client was not in favor of Fremont.
Yes.
Okay. Did you know that Gull Lake is one of the top ranking schools for education around, as well as they also have the Promise program that Porter's tried to discuss with you?
I did recently learn that.
Okay. Have you ever taken Demetrius to the ER without notifying Porter right away?
Not that I recall. I think I always text him right away.
I'm going to direct you to page 11. Oh, excuse me, Exhibit 11. Pardon me, this is a proposed Exhibit 11.
Page 11 or where?
Proposed Exhibit 11, my apologies. It's Proposed Exhibit 11. And I'm looking at page 99 and 101.
Okay.
All right. And what's the date of the one on page 99?
12/12/2022.
Okay. And on page 101, same question.
That is February 1st, 2022.
Okay. And specifically on page 101, I'd like you to look down near almost the end of the page that says final diagnosis. What was that final diagnosis?
Accidental drug ingestion, initial encounter.
Do you remember what that was about?
There was a bottle of medicine on my upper cabinet, and Demetrius climbed up and got into it and spilled the bottle, but I felt like there should have been more in it. So I panicked and I took him to the ER. I did text Porter to tell him, or called Porter to tell him, sorry. Took him to the ER and they said there was nothing in his system.
If I told you that there's nothing in the phone logs or text messages that indicate you took it, that you told Porter any of that, would that surprise you?
Actually, yes, because like I said, I call him for a lot of things like that, especially because, as we've already established, my anxiety gets a little higher about my child.
Okay. So it's your testimony that you notified Porter prior to that visit, that he was going to the ER?
I called him on my way, yes.
Okay.
I can also go back through my text messages if you would like to try to find that exact one to be sure.
Well, I don't think we have time for that right now, especially given the rest of what we have to go through. But I do appreciate that offer. Now, on same exhibit 11, page 115, doesn't that also address some of your medical issues? Specifically that you're bipolar or have been diagnosed with bipolar?
Yes.
Okay, but when I asked you about what you'd been diagnosed with, you failed to mention bipolar, correct?
I might have. I have a lot of mental health issues. I listed a bunch of them. I apologize.
You take medication for your bipolar disorder?
I do not. I use marijuana products, the pills.
Are you aware that marijuana products are not approved to treat bipolar?
It would depend on the studies that you look at, but no, I was not.
Have you talked with your doctor at all about managing bipolar through marijuana consumption?
My doctor, no. My therapist, yes.
Okay, is your therapist a psychiatrist who's able to make medical diagnoses and make prescriptions?
No, I haven't talked to a psychiatrist since I got diagnosed.
Okay. Regarding the fact that your mother has made appointments for Demetrius, hasn't Porter raised these concerns about her making those appointments with you?
Not since the last one she made, and she hasn't made one since then.
Okay, but the question was, did Porter raise concerns?
Yes.
Okay. You typically have to be reminded to do things multiple times in order to follow through, such as paying on bills and things that have been presented to you?
Yes, and in my own case, so like my bills, things like that, I set an alarm or like a reminder for it.
Is there a time at Grace Health where you notified Porter that the bill there was extremely high and asked him to take care of it?
If I recall, I asked him to check into his insurance because his insurance should have taken care of some of those things, and they were saying that there was a problem with it.
All right, but isn't it true that when Porter tried to take care of that, he was notified he had been removed from the information at Grace Health and therefore couldn't?
That is what I was told by him.
Okay. Did you have to call Grace Health to put Porter back on the document so that the bill could be taken care of?
When I called, they said he was already on the documents. So I didn't have to put him back on anything. I never took him off.
Okay. So the fact that he was removed was just pure coincidence.
They said he was never removed. They said they weren't entirely sure what the issue was.
Okay. So when you first moved with your grandmother in 2020, you stated it was yourself and your friend that moved in. Is that correct?
Yes.
Was Demetrius living there with you when you lived there?
No, he lived with his father.
Okay, so you didn't have any overnights at that time?
No.
Okay,
And yes, I stayed there.
okay. Do you believe that you respond to all of Porter's texts in a timely manner?
That would kind of depend on the circumstance. I respond when I see them.
So the question, I guess I'll refine it and say, haven't there been text messages where you don't respond until the following day or even not at all?
More than likely, yes.
Okay. Did he ever threaten to beat in your door or to hurt you in any way because you weren't responding?
No.
Okay. Other than the soccer incidents, wasn't there another incident where Porter didn't respond quickly enough and you threatened him again?
I don't remember. There could have been.
Okay. I'd like you to refresh your memory using Exhibit 18, page 27.
Okay.
All right, so I'm looking at text messages that were exchanged on March 19th of 2023, correct?
Yes.
And the first one is sent from you
Can't hear you, Miss Storm.
and the next first one is sent from you at 13:05, which have been a 1:05 in the afternoon, correct?
Yes.
All right, can you read that for the court?
Says, hello, am I getting him from you or school tomorrow with a question mark?
And then an hour later, you send another message and you say,
I need to know so I can plan accordingly, please.
And then 7 minutes after that, you write,
You got about an hour to respond, whether it be a text or a phone call to let me know my kid is alive before I come knocking on doors. I don't like to act crazy, but you know that not knowing anything about if he's okay or not and not answering sends me into panic spirals. So let's save us both some trouble.
so why did you think it was okay to send him that threat to knock on doors?
Because we had already established that I go into panic spirals. It's part of the thing that made me start going to therapy more heavily, was so that I could learn to deal with those panic spirals when I don't get responses and don't know what's going on with him.
Okay.
Him being Demetrius, not Porter, sorry.
So why did him not answering your question about who's getting him from school over the course of about an hour and 5 minutes, why did that send you into a panic?
I don't know how to explain it. So my brain does this thing where if I can't guarantee the answer is that my kid is okay and that, or our child is okay, and that there's like another reason that there isn't a response, I automatically think the worst. Pessimism to the worst degree. The anxiety ratchets to ridiculous amounts, and then I'm like, something's wrong. That's why I'm not getting a response. And it just, I don't know how to explain it. It's something my brain is working on.
Okay. So you've testified that you would like to handle disagreements with Porter face to face, but what happens if neither of you still, what if the two of you are still disagreeing at that point? What are you going to do at that point in the future? If the court says we have joint legal custody and you two are in a disagreement and you guys still disagree, what are you going to do?
At this point, I think the best thing for either of us would be to walk away and come back to it, which is what we've done over like the Taekwondo and things like that. And I feel like it's the easier option.
What if it's a decision though that can't wait, like schools or doctors, things like that, things that can't wait for you two to just calm down and talk it through?
Well, then I guess we would have to sit there and kind of go back and forth and negotiate it or figure out what's best right there in the moment.
Are you going to do what you want to do, make your own decision, even if he doesn't agree, the way you've done prior?
No,
Okay. So why are you not going to do that now, but you did it prior?
because before there was a lot of different other things going on, playing behind the backgrounds. Now, all I want is for Demetrius to have whatever is best for him. That's why if it comes to the insurance, he's not on my insurance. I won't make those decisions. As for schooling, going back and forth would just be easier at this point. Like figuring it out together.
Does that mean him coming to agree with you? Does that mean him having to make the compromise?
Not necessarily. It would mean looking at what is absolutely best for Demetrius and then going based off that.
Okay. What if you guys disagree on what's best for Demetrius?
That I'm not entirely sure. I guess the court would be the ones to decide at that point.
Okay. If you need a modification in parenting time for what other reason, how much notice do you think is appropriate to give that other parent?
It would depend on the situation, but I would hope for at least a couple hours in advance.
You think just a couple hours is appropriate notice?
Depending on the situation. Because that's a very broad statement. There's things like If it was going to be a work shift switch, I would want to know at least a day ahead of time. If it was going to be something that you can't control, like a flat tire or something like that, I would hope that it would be okay to have less timing.
Those make sense. So I'm now gonna pivot to back in June of 2023. Why did you not tell Porter about the fact that you were going to send Demetrius to Detroit until Porter asked you for your schedule?
What page?
I'll rephrase that. So in June of 2023, there was a time that Porter asked you for your work schedule, okay? And at that point, you said that you were not going to send Demetrius to him because he was going to Detroit. Do you remember that incident?
I think so.
I'll ask you to turn to page 60 of Exhibit 1860. If that will potentially help you refresh your memory.
Okay.
So this is on June 25th of 2023. And you communicate that Porter will have him back on Thursday, but other than that, you have plans this week and don't need him to be picked up, correct?
Yes.
And he mentions that there's a dentist appointment on Tuesday that he was planning to take him, and that he confronts you about whether you've got the whole week off or not because of this dentist appointment issue also, correct?
He asked where he's going, that he will be out of town, yeah.
Okay. And so then you mentioned that he'll have to reschedule the dentist appointment because you won't be in town. Said you weren't aware of the appointment, correct?
Yes.
Okay. So, but my client responds that, why don't you just read what his response was?
I said we'll have to reschedule the dentist because he won't be in town. I wasn't aware he had an appointment. He said, so you're trying to keep him from me because I sent him to school. Really, that's super petty. Like I said, he has dentist appointment. We told you he had appointment, so you knew about it. I was never told about any plans. Since when and where is he going that he will be out of town? I said, once again, I'm not keeping him from you. I was not told the day, actually. Also, I don't have to discuss everything I do with him on my days as long as he's there on your days. And he said, by the way, him, I don't know what that word's supposed to be, summer school there doesn't affect the battle, oh, I think it's going to summer school there. It doesn't affect the Battle Creek Promise as it's summer school. Yes, you do need to communicate with me if he's not going to be in town. That is something I do need to know. As we both know, you would want to know as well. Also, yes, I did tell you the exact date when we were standing in the driveway and you asked for paperwork. It's not my fault you don't remember. And since when have I not got him on your days? I get him every day. The only difference is on your days is he sleeps at your house. So what is this, something you're going to try and do every week now? And I said, actually, you only get him on my days if I cannot, unless you ask differently, and that's no longer an issue. So yes, on my days, I will be picking him up. You all often do things out of town, and the only reason I know is because you get tagged in pictures. So Please don't try that. We will be spending time with family and he will be to you on Thursday. And then I said, what time is his dentist appointment? Do you want me to continue all the way
Yep.
through?
Yep,
Okay.
might as well finish up the conversation.
He said, I never agreed to that, nor would I. And since when have we ever done that? The only day you have ever picked him up is on your days off, and that is once during the week. I am not okay going that amount of time without seeing him. How selfish and petty can you really be to make it to where he sees us every day? So now he's only going to see me or see us towards the end of the week. Don't you ever stop to think that what you're doing to him and his mental state of mind when you do shit like this? You think you can change things to however you want to when it suits you. So the thing with that is never do I take him out of town on days that he is supposed to see you and say, oh, sorry, you won't see him today because I'm taking him out of town, but I'm not going to tell you where. You would lose your shit. You like to bark orders and want things done a certain way, but you never do as you say. Why does it matter if you're going to be out of town, right? And you just threw a fit about me taking him to school for 2 days because you choose to pay for daycare, but now what, you're not sending him all week. So again, it's okay for you to do whatever you want and make whatever decisions for our son that you want to suit you, not what's best for him. And I said he's going to learn about his culture and his history with his family, something good for his education. I am allowed vacation time at his school, which I am using, if you must know. As for you seeing him, I didn't say you could never pick him up again, or if you asked or he asked, he couldn't come to you, but I talked to my child and I know that this is something he would be okay with. I'm sorry that you feel as though you are having orders barked at you and being treated unfairly, but your feelings are not my concern. My child is. As for the dentist appointment, I am trying to have him here for it. It is not that hard for me to slightly deviate our plan to have him to an appointment and then go back to it. And then I said, as well as we're basically about to get the same amount of time with us switching every other Wednesday, unless that's an issue now. You are also always free to call his phone and talk to him. It will be charged for that reason.
Okay. So on that Thursday, is it true that you had your mom send Demetrius back to Porter?
I believe she did drop him off, yes.
Okay. And were you aware that it was supposed to be a 2 o'clock exchange?
If I'm being honest, I don't remember what time we talked about, but that sounds about right.
Okay. Are you aware that your mom hadn't even left Detroit by that time and therefore was over an hour and a half late for that exchange?
That, honestly, I do not remember, but
Okay.
if so, that's not cool.
Did Porter text you and threaten you or freak out because she was late, even though he had an appointment that had already been rescheduled once?
No.
Okay.
Though if I could elaborate, Porter doesn't have the same mental health issues as I do.
Okay. Is this in 2023 or 24? In 2023, did you tell Porter that you were taking a trip to Disney?
I did.
Okay. And why did you wait? Why did you not tell Porter about not going until Porter texted Demetrius halfway through the trip to see if he was having fun?
Porter was aware that we weren't going because my grandmother was on life support.
Again,
And
if
I
I tell
said
you,
that.
you said that she was on life support. You didn't say that you communicated that to Porter in advance.
I did communicate to Porter that my grandmother was on life support and I wasn't sure if we were going to go.
Okay. So if I told you that nowhere in your text messages does that appear, would that surprise you?
No, because if I recall, that conversation was face to face.
So why would Porter have to wait until, why would Porter then text Demetrius halfway through the supposed trip and ask about Disney if he knew that he wasn't going to be at Disney?
I don't know. I can guess at him forgetting, but again, that I do not know.
Okay. And you've talked about how you allow Demetrius to get his hair cut with Porter and that you don't have a problem with it. But isn't it true that you have had a problem with it in the past?
I did, yes.
Okay. And isn't it true that on or about July 26th of 2023, you went and took Demetrius to get his haircut without telling Porter, even though Porter had said that there was an appointment made to get the haircut together?
I would have to go back and double check, but I could have.
I'll have you look at page 75 to refresh your memory.
Okay.
Okay. Did that refresh your memory?
Yes.
Okay. And so how does that change your answer, if at all?
I literally said I asked and got no answer.
Okay.
So
Wasn't there a moment, a point in time that you told Porter that you might move to Detroit if you couldn't figure something out? And that he would, go ahead.
I was just gonna say yes, if I couldn't find somewhere to stay, I
Okay.
would.
And at that time, did you tell him he would just have to deal with it and go through the courts if he didn't want to be without Demetrius?
That I would have to go back to because if I remember that conversation, I said that would be a last resort. It wasn't necessarily what I wanted to do.
Okay, but that you still said, and I'll direct you to page 33 to refresh your memory, but you still told him that he'd have to go to court to deal with it if he was unhappy with that, correct?
I did say we would just have to go through court on that because neither one of us would have given up our time with Demetrius completely, and I knew that. It says that is my very last resort. I do not want to uproot our lives.
So when issues arise with Demetrius, whether it be these marks or other things that Demetrius has said or done, do you talk to Porter about it? Do you ask him about these things, or do you just state that whatever happened, happened, and therefore he needs to accept it?
I'm not understanding the question. What marks?
Sure. And I'll directly draw your attention to page 122 and 123.
If you're talking about the Santa Claus thing, I did just say, please do not tell our son that Santa Claus isn't real.
No, my question is essentially, do you ask Porter about these things, or do you just tell him? Do you ask him, do you see what Porter had to say, or do you just assume that based on what you've heard that that's the case and lash out at Porter for it?
I don't lash out. I will say things in a very matter-of-fact way. So like, if Demetrius said that, or if Demetrius says, she said Santa Claus isn't real, I will say, hey, please don't do this. And then if he didn't do it, then cool.
So you just automatically assume it happened before getting anything from Porter regarding the situation? You just tell him?
9 times out of 10, yes, I believe my child over everybody.
Okay, but I'm saying how you handle these situations.
And I'm
You just
telling you
go
that
at Porter, correct?
it's not going at Porter. I am a very matter-of-fact person. I don't start off with like a, hey, how you doing? This is what it was. I literally just say, hey, this is the thing that I found out. And I've tried to work on that because he did say that it was an issue, but I'm a very matter-of-fact person.
But you don't at any point say in these conversations, what happened? What's from your perspective? What can you tell me about it? You just launch into it, correct?
Yes.
Okay. And in fact, regarding the Santa thing, you found out that neither Porter nor Alicia had actually said anything about Santa, correct?
Yeah, afterward, he said another kid said something.
Okay. So you jumped to conclusions without talking to Porter about it.
There was no jumping to conclusions. I believed my child, and then we found out more information.
Okay. Turning to the ADD, ADHD diagnosis, when you and Porter initially talked about getting anything for Demetrius for regarding his ADHD or a potential diagnosis, how did that conversation go?
I believe he wanted to wait off until he was completely diagnosed.
Okay. And did you agree that Demetrius should actually be diagnosed to hold off on taking any steps towards buying anything or treatment?
I did agree that he should be diagnosed, and I said, okay.
Okay. But then you ended up buying that shark necklace that we heard testimony about, correct?
My mother bought the shark necklace, but yes.
And you allowed him to wear it and to keep it?
Yes.
Okay. So once again, your mother made a decision that neither you nor Porter made a decision on?
Yes.
Okay. Didn't my client express his concerns multiple times about the shark necklace, among other things?
Yes, and I told him that if it created an issue, we would take it away, and once it created an issue, we took it away.
Okay. And yet Porter was concerned enough about it to bring it to your attention multiple times, but that wasn't enough for you to consider that viewpoint?
No, because at the time it felt like he really just wanted to go against anything that I said.
Okay, so you just assumed it was because he was being contrary, not because he might actually have a point.
Yes.
Okay. Now you stated in your testimony that Porter rarely ever was at a doctor's appointment, but I did provide you the medical records for Demetrius as part of the exhibits. I'm assuming you didn't go through those.
Some of them, yes, but I'm not going to lie and say that I remember what they all say.
Okay. If I told you that I went through them and only found 5 instances that Porter didn't go to any appointment throughout Demetrius's life, do you think that would be wrong?
I would think that it would be slightly off, but again, my memory's not the best, so I could be wrong.
Okay. Regarding the 21st century program, you said it was because your cousin worked there?
She works for it or worked for it. I think she quit recently.
Didn't you hear her testimony saying that she wasn't related to you in any way?
That's not my cousin. That girl's name is Ronice. My cousin's name is Raquel. Raquel is a slightly lighter skinned, shorter girl.
Okay.
There are 3 people usually that are there for 21st century. Miss Ronice is like in charge. There is a taller, light-skinned man, Mr. D, and then there is Raquel used to be there.
All right. You remember when you were advocating for Fremont prior to kindergarten starting?
Yes.
Do you remember that Porter indicated that before anything was decided, the 2 of you needed to talk about it?
That sounds right.
And didn't he state that just because you went to Fremont and that your family was on the board doesn't mean that that was necessarily the best choice for Demetrius?
Yes.
And at that time, Porter expressed to you that he felt that Demetrius would do well at Montessori and was very active and felt he'd be engaged there.
Yes.
And when you and Porter were having issues at the daycare, did he not tell you that Montessori had a free summer school program?
I don't recall that conversation.
Okay. Do you receive tips at either of your jobs?
Yes.
What do you receive in tips at each location?
It would depend on the day.
You could give me an average, that'd be fine, an estimate.
The dude, I averaged like $45 a day, if that. At Vegas, if it's a regular night, I average about 50, $60 if they're feeling nice. If it's a party, it goes up.
Okay, but around 50 or 60 bucks on the regular?
I'd say about so.
Okay, and is that each night that you're working?
No, sorry, combined. Like I said, I'm trying to get my dancers to tip me again.
Okay, so the 50 to 60 is the combined for the weekend unless there's a party or something?
Yeah, Thursday, because I work Thursdays and Fridays.
Okay, you no longer work Saturdays?
I haven't worked Saturdays since I stopped bartending unless it's a switch shift.
Okay. Do you work at the Dude on Saturday at all?
If I'm not off, then I work the closing shift.
What do you mean if you're not off, you have the closing shift? Can you just explain that a little more?
So normally I have Saturdays off, but because I am a shift lead, if they, need me, I'm closing.
Okay. Sorry, some of my questions on this sheet are duplicates, and I'm trying to skip the ones that are duplicates. That concludes my questions for this witness. Thank you.
Thank you. Ms. Ives,
Thank you, Your Honor. I'll just be kind of brief. Regarding uh, the instance that you were questioned about regarding the removal of Porter from the daycare center last summer. Did Porter still have access to records if he wanted them?
If he went up there and did the things himself, yes, he would still have access.
So he could still have created his own account, he just was no longer on yours.
Yes.
So it didn't mean that he was denied access, correct?
No.
And then have you, with regards to the Montessori school, have you been able to get any records whatsoever?
Still not able to, no, ma'am.
Have you contacted them will they give you like attendance information when you call the Montessori school?
No, I did have one time where a secretary slipped up and told me he was there, and that is how I knew that he was for sure going there. Other than what Porter said, but other than that, no.
So at this point, Montessori won't give you any information regarding your kid.
No, they told me that the only person on there right now is Porter.
When was the last time you checked to get any information?
Right before this trial started, was the last time that I went up.
So if he has put you on as a contact person, since the trial started, it would be news to you, correct?
Yes.
What was going on that week of June of 2023 when Demetrius went to Detroit? Did you guys have plans?
It was they were doing a thing for the march. My grandmother was a freedom rider, and they were going through the whole, this is what they went through, and kind of they did the same walk through the streets that they did. And then there was a trip to the African American Museum with my mom and my cousin Carol Ann, my niece Bella.
So is that a vacation week that you had planned?
Yeah, once my mom told me about it, we did plan that out, and I talked to the school.
Has Porter asked for any vacation week, or have you ever reciprocated and give him additional time during the summer so he can do something?
They did go on vacation for like a week. I don't know if we necessarily talked about getting that time. It was kind of just they were like, we're going here, and I was like, okay.
All right. So do you think it's fair that you each have some vacation time during the summer?
I do.
Um. In all these messages that you've had back and forth, did you ever feel that any of these messages rose to the level of that you guys really just didn't like each other? Or, I mean, how do you feel that these messages were between you and Porter as far as getting along?
It a lot of times it felt like they were just, you know, arguments on arguments, like it wasn't meant to go anywhere.
What do you mean, Matt? What do you mean by that?
Like there was no solution. It felt like it was just going to be a back and forth either way.
Okay. Now that Demetrius is now going to Serial City, are you okay with Porter's decision to go to Serial City?
Yes.
Do you still want to be involved in those appointments and have notice?
I would still like to have notice, maybe create like a calendar that we put all of his things on or something so that we could remember it.
And regarding that eyesight issue, weren't there other situations that came up that caused you concern about the eyesight that were happening at the daycare?
Yes.
And would that be the bruises that he was getting because he was running into things?
Yes.
Now, why these times when your mom was making appointments, why wasn't Porter making them?
Honestly, I'm not entirely sure. Anytime my mom has made an appointment, it's been a time that I've expressed something to Porter and then I get frustrated and I talk to my mom about it and my mom's like, well, I'll just go ahead and-"
Objection to what your mom said.
Sustain.
Without saying what your mom said.
Well, I wasn't saying what my mom said. I just was saying she just goes ahead and does it. I didn't, sorry. The way it was phrased was wrong.
During those times when Porter was picking Demetrius up from Bright Lights last summer on those Monday, Tuesdays, and I don't know if it was Wednesday or alternating Wednesdays. Was that every week?
Most weeks, yeah. I had days off on Mondays and Tuesdays every here and there, but for the most part.
Was it your expectation that if you didn't have to work or got off work early, that Demetrius would be with you on those days?
Yes.
Does Mr. Porter ever offer you time with Demetrius when he has to go in on those Saturdays or when he's going out to his bike club or doing something away from the house on the days that he has Demetrius?
No,
Would you like him to?
I would.
And do you think that should work both ways?
I do.
When you when Porter indicated to you that he decided to put Demetrius into the Montessori daycare last summer, or Montessori school daycare, however you want to phrase it. Prior to that point, had he ever contributed any money at all to the daycare?
I think there was once or twice maybe where he helped with like half, but
So you
I
had,
usually paid that myself.
so you maintained all the daycare expense up through the time that he was removed from Bright Lights.
I paid for it up until the principal told me that I could try to get a grant or a scholarship or whatever it was that Demetrius was on for the little bit that it was an actual like school year time. And then I went back to paying it.
All right. This anxiety that you talk about, do you work, or that's been mentioned, Do you see your therapist regularly about that?
I do. We've worked on some breathing techniques as well as I've worked on, she says they're finding the fact. So what is the fact that I know compared to the feelings that I'm having so that it'll calm the anxiety at least just a little bit to help me think through and figure out like, okay, is there actually something wrong? Or am I just feeling like there's something wrong because I don't know what it is?
Do you believe that your therapy has helped you, at this point, like, be able to avoid those anxiety situations?
I think it's helped me to, I wouldn't say completely avoid, but to take them down, yes. So it's not like I just never have panic attacks anymore. It is now to the point where if it does happen, which they're rarer or more rare, but if it does happen, instead of automatically freaking out, I can stop and ask myself, like, do we need to have this extreme of a reaction, or are we triggered by something else?
One moment. Okay, I don't think I have any further questions.
Okay, thank you. Guess I'll ask Miss Miss Ives, because you had reserved on your direct to your client and any potential recross or redirect, et cetera. I look back through my notes. I don't see that you've, oops. I don't see that you've asked much. I just want to say, are you intending to call your client back or something?
Your Honor, I don't intend to. I mean, I want to discuss with my client, but I think just in light of trying to put an end to this case so it doesn't go on any longer, I think we might be closing our proofs.
Okay, I'm just, so you're resting at this point?
Well, I just want 1 minute with my client to see. I think we've got a couple witnesses waiting, but
Yeah, I have 2 people in the waiting room.
I wouldn't mind a 10-minute recess for her to talk with her client
Okay,
and for me to
why
use
don't
the
we
bathroom.
take a recess for 10 minutes and then we'll come back.
Thank you,
Okay,
Your Honor.
pause here for the record for a moment. All done. We are back on the record.
Okay. Ms. Ives, what are your thoughts, or what are you gonna do as it relates? Are you resting or what?
Your Honor, I believe that, we're gonna rest. I think the court has enough information to make up its mind at this point. And so, I know it's a tough call, but and I know my client has a right to call other witnesses and we've had them waiting, but I just really think that, given the issues that are before the court, I think the court can make a decision based on what has been presented.
Okay, thank you. Ms. Storm, I knew you said you had some rebuttal witnesses, but I don't know that Ms. Ives has presented anything that would necessitate rebuttal.
I opted not to call any rebuttal witnesses. I had discussed with my client the potential of calling some additional witnesses. I know Ms. Ives had discussed potentially calling additional witnesses for rebuttal. Since she is resting and has no rebuttal witnesses, I also have no witnesses and would rest.
Okay, thank you. With that, I guess Ms. Storm will allow you to do your closing argument.
Thank you, Your Honor. I'm going to try and take this broken down via issue. And I'm going to start with the school issue, Your Honor. We're asking for the court to order that Demetrius be able to attend Battle Creek Montessori. A lot was made regarding whether it was direct or indirect teaching. And I want to make it clear that Battle Creek Montessori has a standard curriculum that must be achieved, and that children are given a choice on what to do next, not on whether they will even complete the assignment. They essentially get the choice to work on things in the order that they desire, but the actual curriculum and things that are assigned all have to be done. It isn't this willy-nilly, do whatever the heck you want with no instruction or direction type of time, the way Ms. Ives has tried to paint it in earlier questionings. Battle Creek Montessori also allows for drop-offs as early as 7:30 in the and afternoon evening pickup as late as 6 p.m. The early drop-off prior to school opening actually is 6:45. So either parent would be able to drop off prior to work if needed. And any of the before and after care there is mostly activities and sports and games outside, chance for Demetrius to be a kid. Those are the things that he would need for any before and after school care. Because we've heard testimony that he does excellent in school. He's very advanced. He's able to do the work, and that he's socially well adjusted, that he's got friends at both Battle Creek and at Dudley, that he gets along well with his peers. The thing that Demetrius struggles with is his ability to behave himself in class. And we heard testimony that that struggle is happening in Dudley, but it's not happening in Battle Creek Montessori. And I think the court should ask itself, why is this the case? And we would argue that it's because Battle Creek Montessori is structured in such a way that not only is it tailored to the individual needs of the students, but it also allows the students to be able to grow at their pace. This allows Demetrius a better opportunity to be able to focus on what he needs, behavioral assistance versus any academic or social issues. Mother has advocated for Dudley, but has recently picked Fremont. She registered or signed up or got on the waiting list for Fremont without any discussion or warning, knowing that this issue is still pending. Battle Creek Montessori also has a registration deadline and a wait list that we would need to do, but my client hasn't done that. He's respecting the court's decision that the court is the one who gets to decide this. He's not going to just go forward and make this decision while the court is pending. The reason that Demetrius was picked up early was to try to accommodate having two students getting out roughly at the same time and not being able to be at two locations at once. My client never got Demetrius out of school more than 30 minutes early. The average amount of time out was actually 20 minutes, and that is supported by the testimony that was given by the school officials on that from Dudley. The 21st Century program at Dudley, making it a mandatory thing. Again, Demetrius is not a student who needs a mandatory before and after school program to assist him with his academics. He is excelling and he's clearly advanced, and these are his goals and needs are going to be best met at Battle Creek Montessori. Not only is it tailored individually, they partner with older kids to promote further growth in that mentorship program. And just because Bearcat Advantage is not a part of the Battle Creek Montessori, or Battle Creek Montessori is not part of the Bearcat Advantage, I should say, that doesn't mean that that is in and of itself enough to sway the court to decide for Fremont or Dudley at this point. The child also has Native American heritage and other things, and the fact that he is already advanced at just kindergarten, the ability for him to be able to get into a school and to get scholarships, it's going to be there. Regarding parenting time, Your Honor, my client is essentially asking for a schedule that mother cannot simply say, hey, I have the day off, and automatically screw things up. The changes last minute are the things that are the most hurtful to not only my client, but to Demetrius, because mother decides to make modifications to her job schedule for whatever reason. We still believe that it was made for the reason to avert or subvert the temporary order, because the timing of the two is just too suspicious. They happened almost immediately after we got that order. Suddenly mom has a job change. My client would like to ensure that if we continue the schedule, where the current overnight schedule that we have now, my client would like to continue to have Mondays and Tuesdays and the alternating Wednesdays, all the days that are mothers, that he be able to have from after school until 6:00 p.m. That he has gotten used to that time with Demetrius. Demetrius has gotten used to that time with him. He comes to count on it. There's benefits to it. There's ability for Porter to be able to get Demetrius's haircut. And it's also availability to assist with any after-school appointments that mother may not be able to make. Again, holidays to remain shared and alternated. My client would like to have spring break, summer break, and winter break spelled out such that parties are alternating spring break, that the parties are sharing Christmas break, whereas one of them, whoever ends up having Christmas Eve that year, gets the first half of break, and whoever has Christmas Day then gets the second half, with Christmas Eve being that exchange day. That any change to the normal schedule should be in a written agreement signed by both parties, and that it must be preferably 48 hours in advance. Understanding some of the reasons that Ms. Newbern gave regarding reasons why last minute notice would be appropriate, I think it can be assumed that those types of reasons, car trouble as far as car won't start, tire issues, flat tire, those are the, train, those are the types of things that make flexibility easy. But if we're going to need something longer because we're picking up a shift or because we're going out of town or any other reason, these are usually things that you have at least 24 hours, if not more, notice. And that's all my client is asking for, is he wants notice. And that regarding family trips, he would like there to be notice in advance of the proposed trips, that any modification or missed parenting time be able to be made up, and that if the trip falls through for whatever reason, that the agreement to change the regular time be voided and they just go back to the regular. So we aren't left with this issue of, hey, we're going to do this trip, and then the trip never happens, and then the child is just sticking around with mom for that week, when we could have gone back to the regular schedule and mom could have used her week potentially another way during the year, rather than Max doing it at that point when there really was no need to use it. Again, making it seem as though she's simply trying to withhold parenting time from Porter, whether she means to or not. And I think that's part of the issue here, Your Honor, is a lot of this is perceived to be very intentional. And mother has indicated that she's not trying to do it intentionally. But the history between the parties results in it feeling as though it's personal. And the lack of consideration by Ms. Newbern, but the expectation that my client is always going to be able to make the consideration, that's not what my client is trying to do. We just want there to be equal expectations from others. Regarding a right of first refusal, my client is not really in favor of that for several reasons. First of all, parties have a hard enough time agreeing on things as it is, to now add in whether or not they agree on right of first refusal. I think that's going to make things even harder for them. If they can offer it to each other, great. But regardless, as far as especially if they're going to be gone for several hours at a time. But to say that anytime my client has to work for a couple of hours on a Saturday, which could be 15 minutes, or that anytime he wants to go do an hour or two out with friends in the evening, that automatically means that it has to be given to Ms. Newbern, I don't believe that that's appropriate. And I feel like that's going to end up causing more problems for the parties of, well, did you give me that for right of first refusal? Was I allowed to get that? Was I not allowed to get that? Which situations are appropriate to use for that? Which ones aren't? I believe that's opening a can of worms for the court. And so while my client would like to be able to have Demetrius more and be able to be the one providing the care for Demetrius, and thinks that Donnie should be able, Ms. Newbern should be able to do the same if he's out of town for something, or was going to be working all day and Alicia wasn't available, his live-in girlfriend. But at the same time, to expect that every single time, given these parties, it just doesn't seem feasible. In an ideal world, yes, they would be able to have that reciprocal right of first refusal. But this isn't an ideal world or an ideal situation. Certainly, parties should offer it whenever possible and consider the other parent first for childcare. But if that's not available, or if it's just for a short period of time, such as an hour or two, I don't know if that really rises to the level of putting in a right of first refusal. Regarding our request for custody, Your Honor, The reason that specifically boils down to is that if we have joint legal custody, these parties are going to be back before you and this court over and over and over again, as evidenced by the fact that we can't even get agreements between the parties on what to do for after school schedules, what school to go to, whether a child should have a shark necklace for ADD, ADHD that hasn't even been diagnosed yet, and things of that nature, all point to the fact that requiring them to have agreement on every legal custody decision for this child's life until the child reaches 18 is going to guarantee that these parties are back before the court repeatedly, and that decisions for Demetrius are not going to be made. We heard testimony that mother often either couldn't get appointments because of the delay to get appointments at the doctor's appointment, or just a failure to do so, and her mom would do it for her. We heard testimony that my client tried to be proactive in getting Serial City Medical Center because they're able to get in. And mother even admitted that, yes, they're easier to get in and that she has no opposition to them being the medical provider now. My client, she admitted that my client should be able to make the medical decisions because it's his insurance. I don't know if that reasoning in and of itself should do it, but the fact that she's already said that she just wants to remain informed, that seems right there that she's already willing to allow him to have, at least for the medical, sole legal custody. Again, my client has historically kept mother informed on appointments prior to the appointments, prior to the medical issues, or as the medical issues are emergent. I have shown through repeated text message examples that mother has testified to one thing, but the reality of the situation is completely different. Mother often does what she wants, regardless of whether she's discussed it with my client or whether he's in agreement. And alternatively, my client still consults with her first regardless. We had the testimony that when it came to the Glass's second opinion, that my client talked with her about, I want a second opinion, and she said, okay. And then he made the appointment. He didn't make that appointment saying, hey, I'm getting a second opinion. It wasn't a demand. It wasn't just explaining a fact. He said to her, this is what I'd like to do. And he waited for her response. And when she was in agreement, he went forward with it. He didn't take steps just assuming that she would be in agreement. And he didn't take steps just hoping to ask for forgiveness rather than permission. There was a delay in getting an eye appointment and never told my client in advance of the appointment. And it was actually my client's second opinion consult that actually resulted in a correct prescription for Demetrius and a different pair of glasses needed. And had mother not rushed into things by not telling him about the original eye exam and trying to do it behind his back, they could have potentially done this right the first time. And to say that she told him in passing when she made the appointment, and then 3 months later, he just happened to forget. Testimony and the exhibits today and in the prior days have shown that my client isn't the one with the memory problems. Ms. Newbern is the party with the memory problems. She needs multiple reminders to be able to do things. She testified that she sets herself reminders on her phone, and that, yeah, she needs to have things brought up to her multiple times in order for her to remember it. So to say that my client is the one who's not doing the informing, but to believe Ms. Newbern admitted herself that she has her own memory problems and doesn't remember everything. So to say that we should rely on her testimony over my client's testimony, I don't believe holds weight, because my client, through his testimony, through our witnesses, and through review of the exhibits that weren't admitted, but were at least reviewed, shows that his memory reflects what was actually communicated between the parties. And unless there's actual proof, and not just well, I told him in passing at one of our exchanges, that doesn't do us any good, Your Honor. Unless it's in writing, it really doesn't do much. And so I think I'd also like to ask that the court order that any communication regarding Demetrius be in writing at this point, because simply saying that we can do this on memory and verbally, agreements are not standing, agreements are not sticking, information is not being shared, and information is not being remembered. Regarding mother has communicated to my client several times that she's going to do what's right for her and her child, that it doesn't matter, that this is a mother state, that mom's going to win, that he's just going to have to deal with it or take it to the court if he doesn't like it. That's not a co-parenting relationship outlook. That is someone who believes that she has sole custody already and that she's going to do what she wants, regardless of what my client says. And it's only when somebody else brings it up that she'll potentially consider it. That happened with the shark necklace. My client brought it up to her several times, and it wasn't until the teacher confirmed that it was a problem that she said, okay, yeah, we won't have to do the shark necklace anymore. Also, there was the testimony regarding, oh shoot, there was something else that my client testified to that was an issue, and that Ms. Newbern said, oh no, it wasn't. But when it was confirmed by a third party, oh, that was the communication. When the Santa Claus information, rather than have a conversation with Porter about it, find out what happened, she jumped to conclusions and just said, hey, don't tell him that Santa's not real. Rather than just saying, hey, Demetrius said that this, that, and the other about Santa's not real. What happened? Where did he get this? She automatically jumped to the conclusion that my client or his girlfriend must have said something. And despite being told that it wasn't the case, it wasn't until later that she finally believed that, oh, I guess he must have heard it from someone else, that it wasn't them. Jumping to conclusions like that is not going to help these parties co-parent. And Ms. Newbern's own testimony indicates that she is likely to fly off the handle because she gets paranoid and she gets anxious and she gets worried. And bipolar and borderline personality disorder are two things that are not treated by marijuana, medical or otherwise. She has no prescription for her bipolar or borderline personality disorder diagnosis. She's not taking medication through a doctor, and she's only talked about it a little bit with her therapist, who she has admitted is not a psychiatrist who's able to recommend a course of treatment or medications or prescribe any of those. She's not adequately taking care of her own health, and that's impacting her ability to parent because she's flying off the handle when my client isn't able to respond within an hour and 5 minutes. That was the Santa Claus issue. That wasn't even including the time when he was when there was the soccer issue, when he left the phone in the car. Mom intentionally makes things difficult with my client and then doesn't communicate with him. She removed his access from the Bright Light Daycare to her code when she was mad at him. She never mentioned there was bruising concern regarding connection to the glasses. And despite while being concerned about the bruising while at Bright Lights, Mom continued to use it over Dad's objection for a desire for safety and closer observation. Because either the child was getting injured outside of daycare, in which case parents should know about that, or if he is getting injured at daycare, accident or otherwise, the fact that they couldn't testify to what had happened shows that they weren't giving Demetrius the close enough care to be able to even tell if these injuries were happening there. So how could they opine whether or not glasses were a problem if they weren't even sure what was going on in their own daycare? And the point of the Bright Lights Daycare issue was that when Mom was mad at him, she took him off her account. And then she says, oh, well, he could just make his own account and get his own PIN number and have his own access that way. I don't know why he's mad at me. It's because she didn't tell him she was removing him from that access. That was something that they had agreed upon and had been doing for months. And then when she got mad, she changed it. And she's trying to say that she didn't do that. Mom likes to minimize things, just like she did when she talked about throwing her phone and breaking the windshield of her car. I don't know what her windshield is made out of that a phone hitting it would cause it to crack. But I think this court is aware that windshields don't crack easily. Certainly not from a cell phone hitting it from just whoops, flying out of your hand. Gestures are not. In my most excited and animated state, I have never thrown something so hard that it breaks my windshield. And I have never seen or heard of that happening before. I believe Mother is minimizing this incident, that once again, she lost her temper and that she either punched or threw something else at the windshield hard enough to break it. Whether she wants to admit to it or not, that's what happened. And the fact that she was more concerned about child staying at Bright Lights, which had a cost to her, over Battle Creek Montessori that had an even less cost to her, it doesn't hold weight for her argument that she's the one paying all of the bills and this, that, and the other, and that Porter doesn't contribute. Because he suggested to not only go to a different daycare that would hopefully be safer or at least more aware of what Demetrius was doing to injure himself, but would also be a lot less expensive for either of them, that they could share the cost of. So her $215 or more each week could have been $250 a month. It doesn't make sense, Your Honor. Mother's emotional stability leaves doubt on whether she'd be able to co-parent calmly or effectively when in a heightened situation. The overwhelming number of calls and texts to my client in less than an hour because of the soccer game. The game was at 10 a.m. and the calls and texts didn't come in until much later in the day, well after the game would have ended. So therefore, mom's testimony that she was upset about missing the game doesn't hold weight. She admitted actually that she was just upset and spiraling at that time, but she tried to say, well, I was upset because I missed the game. No, the text messages came long after the game was done. It wasn't as though she showed up at the soccer field and said, oh my God, everyone's playing, but Demetrius isn't here. I'm panicked. No, that wasn't what happened. Threats to break in my client's door if he didn't answer, threats to have other people to do that, threats to have her mom come and take Demetrius from him, and offhand comments that she wants to hurt herself or end her life. These are all things that have actually happened. Mother has said that she will do something, but then doesn't follow through, not with making appointments, not for paying for glasses with Porter, not for paying for the Grace Health bills, not for any of it. So again, for her to say, well, she's paying for everything, that's not true. There's a lot that's been left unpaid and that my client has had to take care of. He took care of the Grace Health bill that was outstanding at her request. The parties have joint legal custody now and have been unable to agree. So what makes mom so confident that they'll be able to agree moving forward? She admitted she gets defensive and lashes out at Porter, and testimony supports that while Porter gets upset or frustrated, he typically remains calm and does not resort to abusive behavior that mom does. We had one incident when parties broke up where mom testified that he got physical with her. When all that happened is that they were yelling at each other and he got close to her. She felt the need to back up, that he backed her against the wall. But she then testified that she was able to leave that. He didn't keep her there, that she left. And we've had no testimony that anything like that has happened since, whereas we have plenty of testimony and evidence to show that mom has continued to engage in erratic and dangerous behavior. She even testified that my client has never placed a hand on her, not that day and not any day. She claims that she's done research to things, but then she doesn't provide support for what she found out or how she made her conclusion, not even when asked by Porter. If joint legal is still granted by this court, then my client requests that there be a provision regarding mandated exchange of any research that should be included in these major decisions. If there's a reason that a party is against or for something because they saw something online or talked with someone, that information needs to be communicated in such a way that the other parent can also check out that source, talk to that same person. Because just saying that I'm doing research but not sharing what that research is or how you came to the conclusion doesn't help parties co-parent or facilitate any sort of resolution. We believe that the best interest factors support my client having sole legal custody. I'm going to focus on the ones that I believe weigh in my client's favor rather than the ones that might be equal. My client, I believe, has shown that he can support Demetrius financially and provide him care. He seeks out the medical care for him timely. He wants timely health care.
I'm going to object real quick. I'm going to object at this point because this isn't a physical custody argument. We're talking about legal custody. And I don't know as if the custody factors play into this. I don't think we need to go into this kind of argument, Your Honor.
Okay, well, Ms. Ives, if you look at Michigan Compiled Law 722.26A, the first part says that the court is to determine whether the custody is in the best interest of the child, and the court should consider the following. Factor A is factors under section 3, which is the best interest of the child test. So she can go into that.
Okay,
Thank you, Your Honor. No one is trying to say that mom and Demetrius don't have a bond or love each other. No one is trying to say that mom is not one who has love for Demetrius. But we are saying that she lets her own bias and perspective close her off to being open to anything else. Not only in the text messages, but in her testimony today and in prior days. It's never been our son, Demetrius. It's always my son, Demetrius. My son isn't going to do this, and my son isn't going to do that. And I'm going to do what's best for my son. This isn't just her son. This is my client's son too. And for her to try and say that, to use that phrase over and over again, it just shows what her true feelings and thoughts are regarding Demetrius. My client, as indicated, has been the one to provide the medical insurance for him, has been the one to go to a lot of the appointments, even though mom hasn't told him about all of them, that he schedules appointments when asked to, that he takes proactive action when the medical provider at Grace Health wasn't getting in time. He was proactive about thinking of another provider who would be able to get Demetrius in timely. And he shares this information with mom. Mom doesn't always do the same to him. Porter has been a consistent factor in Demetrius's life throughout Demetrius's life. He's always been in his life, has never once not opted for parenting time, not neglected to take his parenting time, has not put his work schedule above Demetrius for whatever reason. We have testimony that mother even admitted that when they first broke up, she wasn't having overnights. She saw Demetrius some, but she never had overnights. And then it wasn't until she got her new place that she started having overnights. My client has consistently offered, if you'd like me to take Demetrius for you, I can. When she had fleas and needed to go to a hotel, he offered to take Demetrius, which was declined because it was more important to mother for her mental health to have Demetrius with her than it was to just let him stay at dad's. We're going to stay at a hotel on a school night instead. Indicating that she brought food for Demetrius years ago during Porter's parenting time. You know, the testimony was that it was a thank you for watching Demetrius, not because it was requested or needed. Mother has continuously stated, especially today, that she has a lot of mental health issues, that she has memory issues, that she's not fully treating her serious diagnosis of bipolar or borderline personality disorder, that she flips out unreasonably because she gets anxious or, you know, recognizes that her reactions are bigger than they need to be. And she uses this to justify the threats that she's made against my client, not just once, but multiple times. She erroneously believes that my client is jabbing at her in the text, but we went through the text messages, and one that she specifically says, I felt like that was a jab. It was just plain day. It was just plain language. So mom is reading more into these messages than what's actually being communicated. She's not facilitating the relationship between my client and his son, their son. She's attempting to paint herself in the light that she's the reasonable one and able to compromise and support Porter all the time. And she admits that he's not done any belittling to her in quite a while. She admits that she's let her mom do things for her that she and Porter should be doing. She admits that she's threatened to have her mom pick up Demetrius from Porter. There have been posts on social media. There are no disclaimers on these posts or other indications from mom that it doesn't relate to her life or situation. She testifies that she's got some posts of those, but those have never been found. And certainly the posts that she was confronted with, the dozens of posts, not just one or two, but multiple pages, none of those had a disclaimer on them. Her testimony today was all over the place, and numerous times she had to backtrack or admit that she said or did things that she originally claimed that she didn't. She attempts to minimize, again, with the windshield, tossing the phone, and ultimately her testimony holds very little weight, or should hold very little weight, given that she is merely trying to present herself in the best light possible, even though testimony and evidence have shown contrary. Believe the preference of the child is something that should be considered, which of course would be an interview by the court. Although my client would indicate and assert that Demetrius wants to spend time with both his parents and that he likes seeing his dad every day for that after school time. And that it shouldn't just be for a 20-minute, 30-minute time where Porter picks him up and then Ms. Newbern is at his house 30 minutes later, ready to take him home. There is a lot to be said for the attempts made by my client to facilitate and co-parent with Ms. Newbern. The fact that he's asking for sole legal custody doesn't mean that he's going to change anything about communicating with her ahead of time, providing her with information, or her access to that information. Whether she's got legal custody or not, she always has access to the personnel and medical records, and that's by, I believe, state statute. But my client has shown that he's willing to try and work with Ms. Newbern, but his attempts to work with her have failed over and over and over. And to continue to allow Ms. Newbern to make demands, to assert how things are going, it's just not appropriate. So we're asking the court to grant my client sole legal custody so that, honestly, I just find it incredibly distasteful that mother even tried to assert that this is a mother state and therefore she was going to prevail. I think that that's inappropriate. And I think that that's indicative of how she views not only my client in this court case, but also with Demetrius. Thank you.
Okay, thank you. Ms. Ives, closing.
Thank you, Your Honor. I would just start that, I mean, the plaintiff has made some very direct allegations against my client with regards to their abilities to co-parent. But I would like the court to just notice that, I mean, the plaintiff is not acting in Demetrius' best interests himself. I mean, here he is a parent and he's removing a child from school just because he wants to see Demetrius. He doesn't wait until after his girlfriend's daughter gets out of school and then pick Demetrius up. Instead, he routinely picks up Demetrius before school lets out. Why? Because when mom gets out of school, she's going to want to spend, or what gets out of work, she's going to want to spend time with Demetrius. But instead, he's acting in a selfish manner to get the child, not only removing him from school, but then asserting that that's my time after daycare. It's always been my time and I want that. He also, the fact that he made this unilateral decision in June. I mean, the minor child had always been going to Bright Lights Learning Center. My client selected it with the assistance of the plaintiff. The plaintiff had input. It's not like he never said no. In my opinion, this shows actually that they were, at least at that point in time, they were able to systematically agree and they were working together. And the plaintiff was at work and my client knew she had to work now during the day. So she took the efforts to find a solution that was going to watch their child for them. To me, that sounds like that's parents who work together. May not have been, maybe there was a better daycare solution, but the plaintiff didn't come up with one. And the child stayed in this daycare center for quite a while. And luckily, my client, the defendant, was able to get a scholarship so that the child could attend there without cost. And then all of a sudden, come June, even though they had some discussions about perhaps Demetrius should go to a different center, all of a sudden my client gets a message, and that's the one exhibit that's been exhibited, Your Honor, because I think that one exhibit is a telltale sign that kind of shows it's not just my client that has said this is the way we're going to do things. This is the plaintiff sending her a message that, nope, he's in Montessori school on my days. And that's it. And my client hasn't been able to get one bit of information from the Montessori school except for what we've heard here in court. Because she's not on any of the contact information. So I don't know how the plaintiff can say with a straight face that he is trying to include her on these things that are routinely important. The plaintiff is able to access all of the school records at Dudley. I think my client's explained, she's done the best she can to explain her position on the Fremont school. Their son is excelling. I mean, I think the arguments that have been made by plaintiff's counsel regarding the child's needs, the child has done exceptionally well. And when he is at a learning environment for at least 3 what would be 3 days a week, 1 week, and 4 days a week the next week, the majority of this child's time is in a structured school setting. And I think when you heard the teachers, how he gravitates towards this learning environment, I think my client would argue that this is the better type of environment for their son. And she doesn't agree that Montessori fits his needs. We also heard that there's got to be at some point a transition because Montessori doesn't go, it's not all the way through 12th grade. So at some point there will have to be a transition. The other argument about the school, the public school in Battle Creek, is that there's a child here who has an opportunity to take advantage of a scholarship program. And by starting him in kindergarten, he's going to be eligible for a 100% scholarship. And my client is very financially aware of the opportunity that proposes. And I think she's testified that that's important to her. And we would think that that should be important to the plaintiff as well. And he seems to think that the child being very, perhaps, he's very bright child, but that doesn't guarantee a scholarship. And those things can be very competitive. I would indicate that to me, when my client was reading the messages out loud, Your Honor, just in her testimony today, that's dialogue that the parties were having. That's not my client refusing to respond. That's dialogue. And that's the first step in trying to co-parent. And I would say that these parents actually have tried to do that. It's just that they have reached an impasse on the education piece. And that's the primary impasse. My client agrees that the child should go to Serial City. I think that the way it came about, maybe it wasn't exactly clear, but my client has no objection. She agrees with the father. She believes that that was a non-issue, that they talked through that. This idea that, dad believes that all of a sudden time is being taken away from him on Monday, Tuesday, and Wednesday. My client has always felt of that as her days, and that when she's not available, she does what a good parent would do and say, hey, would you want this extra time? And the plaintiff is now using that as a sword against her, saying, aha, you've given up your time, and that's now been my time. He never once offers on his Saturday when he has to go into work that, hey, would you like Demetrius? So it's not reciprocal. I mean, my client would like a reciprocation in that regard because she does believe that Demetrius should be with a parent. If the court agrees that maybe we should eliminate first right of refusal altogether, then I would argue, Your Honor, let my client have her time on Monday through, or I'm sorry, on Sunday through Wednesday, and then Sunday through Thursday, the opposite week, as they have been doing. I know my client testified that she would like that Sunday to start earlier in the afternoon because that's her day off, and she would be able to actually spend some weekend time with Demetrius. She had also testified that, you know, she would like to reserve a Saturday per month in exchange, and then Mr. Ward would have an additional day during the week so that she could plan a Saturday event with Demetrius. We do agree, Your Honor, with regards to the request that spring breaks, summers, they should be spelt out. And I believe that this is a case where standard summer alternating week parenting time is appropriate, and that the parties agree to share during the school week their the custody as they have been doing. We believe that based on the best interest factors, and I'll just go through them, how we see them, Your Honor, because plaintiff did. I mean, we believe that there's love and affection for both parents with their son. They both love their son very much. And I believe my client, you know, these anxiety pieces that she has, it's just because she loves her son, and she's gone into therapy to, you know, reflect, figure out, put tools in her toolbox so that she doesn't have those emotional outbreaks. The ability of the parties to give the child love and affection. I think both of these parties do love their child very much. I think they both act a little bit selfishly because they do love their son very much. And I think that's what you're seeing on both sides of the fence here, Your Honor, because I feel like, you know, my client's position, you know, she wants to spend time with Demetrius. She loves him. She wants him to see him excel in school. She wants him to have all the opportunities. I'm sure she believes Mr. Ward does as well. He just has a different outlook. We believe Mr. Ward is also influenced a lot, though, by his new, also has a minor child who goes to Montessori, who has a child that goes to Serial City. You know, that's always going to have going to be a factor when you start having a blended family, but that's certainly an influence that Mr. Ward has on and his family. We would indicate that the parties have, at this point, Demetrius has been going back and forth between these parties for some time. I mean, he has shared time with them, and I believe my client believes that that should be continued. But just as they share time, they have shared decisions. Like I said, the only impasse that they have had at this point has been the school. So far, over the years, even the medical, whether Mr. Porter went to a medical appointment with my client and the child, you know, whether he was gone, whether he wasn't there 5 times or 6 times or 4 times, I think that's irrelevant. The relevant fact is that both parties have participated in Demetrius's health care. Both parties participate in his education. So both parties are very much involved. My client has testified regarding her mental health. I mean, she knows she has struggled, but I think she does what a responsible parent is. She's got a therapist. I think a lot of the testimony, Your Honor, I mean, none of these incidents happened within the last 6 months. Any of these instances that I would find concerning. The soccer game, for instance, I mean, that was in 2022. And my client was very distraught. She went to the game. I think counsel misrepresented the fact that my client was there and her son wasn't there. And she did. She indicated that she was upset, and she reacted. And perhaps, you know, she now has better tools to assist her with reacting better. But she was a scared mom with with anxiety issues. And so you can see how that developed. I don't think that's any indicative that she can't be a joint legal parent. That just means she's going to be a very concerned parent, and I think that's appropriate to be when you don't know where your child is, when you expect them to be somewhere. We believe that Demetrius's home, school, and community record is one factor that the court should really look at, because we think it favors the defendant's position and the fact that Demetrius is more suited to be at Dudley and in the public school system based on the educator's testimony. We believe that this is where Demetrius thrives the best based on how he learns. We of course believe that the court will take into consideration the preference of the minor child. The willingness of each parent to foster a parent-child relationship. Again, as I said briefly when I started my closing, that you have a situation where, you know, my client feels that every single time she offers something, it's now being used as a sword against her, as if she said, well, hey, I'm going to work overtime, or I'm going to work extra, you know, would you like to have Demetrius? Now it's like, aha, you're giving up your time. And we think that when you talk about willingness to facilitate parent-child relationships, that's what you want a parent to do. But we don't see the plaintiff doing that for my client. And I just want the court to see that and kind of appreciate it, or kind of analyze that for what it is. Because my client has asked for the first right of refusal, and perhaps the court does not find that that would be appropriate. But if the court does find that that's appropriate, it should work for both parties. And it should work on, you know, if my client on Monday and Tuesday has the days off, those should be her days. If those days, if she has to work, why shouldn't the father be available? But the same thing on the weekend. If he has to work on Saturday, why shouldn't Demetrius be able to go with mom if he's got to go to work? She would love some Saturday time as well. We believe this is a case where joint legal custody is very much appropriate, Your Honor. There is nothing, when I look at a case like this, and I've seen some cases where parties are very, very hateful to one another, very, very despondent, or refuse to communicate whatsoever. I mean, that's not this case. I mean, these parties do communicate. But for this school issue, they have gotten through many issues. And we don't believe that the court needs to instruct the parties to provide their research. I think the court should instruct the parties that they communicate with the other parent when they have scheduled an appointment, so the other parent knows, so that the other parent can be there. But I don't think they need to do research. And like I said, other than the school issue, I believe that's the impediment to why we're here today, is where Demetrius is going to go to school. We'd ask the court to order that Demetrius stay in Dudley, that unless the parties agree otherwise, that the child would stay in Dudley. If Mr. Ward would like to if the parties would agree, if they agree on a different school, then great. If they cannot agree on a different school, then we would ask that the minor child stay in Dudley at this time. That if there's going to be a change of school later, that maybe this issue has to come back before the court unless they agree. Otherwise, I don't believe that they have any other significant arguments over legal issues regarding their son. We would ask the court to put into or make orders regarding the pickup and drop off times, so that the parents are clear, so there isn't any ambiguity of how the the parenting time or custody is going to be set. I think that will alleviate a lot of issues for these parents. Is just to have, they've been going on, you know, they haven't had a court order before this case was filed. I think each one probably took maybe advantage of the other on specific issues at times. But I believe that once the court puts an order together, they will have something directly to follow. And I think that would be in Demetrius's best interest. I don't think I have anything else. I think that based on originally, I don't think my client wanted any support, but since I think she's now on some assistance, the court may have to follow whatever the support guideline would be on this case.
Okay, thank you. Ms. Storm, anything else before we conclude?
Yes, just to touch on a few of the things said by Ms. Ives during her closing. Again, if we're advocating for Fremont, why did mom go for, or excuse me, for Dudley, why did mom register or enroll or get on a waiting list or whatever for Fremont? Again, not ringing true. To say that parties have always communicated well or are willing to communicate well, it neglects the fact that mother straight up told dad, communicate through my lawyer. That doesn't show that parties can communicate. And the fact that mom has been trying to stay in line while this court case has been going, she's on her best behavior. Of course, we're going to try and do some things while the court is looking at both parties strictly. We have issues with extracurriculars. To say that we've never had disagreement regarding medical is incorrect because we have the ADHD issue. Dudley has been chosen because she dictated that choice. She chose. There was no other option. And so my client was left to just either file the motion or to just, or to let the court handle it, or to just accept that because it's her way or the highway. My client made accommodations regarding the school timing. Again, it wasn't just to see Demetrius. It was because there was a conflict in pickups in both schools. To say that mom was unilateral decision in June regarding bright lights, mom was actually on board at first with that change. And again, it was only afterwards that she changed her mind again back to bright lights, seemingly despite my client. To say that they were working well together, that was years ago at this point, years ago. We did suggest other solutions to the daycare issue because that's what Battle Creek Montessori was. Battle Creek Montessori at first was daycare, was preschool, was to accommodate that. So to say that we aren't giving options and not trying to come up with alternatives is a lie. We absolutely have. The testimony was that she, from the school itself, was that she actually is on all of this information for Battle Creek Montessori. Why she's not getting information, I don't know. I can only be left to assume she's not actually requesting the information, because if the teachers were, or excuse me, the principal was in saying we give out the information and nobody is saying that we didn't receive, that we received anything from mom and ignored it. That's what I'm left to conclude. How can mom know that Battle Creek Montessori won't meet Demetrius's needs if she's never done any research into Battle Creek Montessori, never talked with this teacher, never done any of that? That contradicts itself. To say that the aha moments, the double-edged sword that, you know, oh, we're going to stick you with the sword now. That argument doesn't hold weight because that's not what this is. It's the fact that mom has brought these issues up. So my client has brought them up in defense to address the reasons why mom has said this, that, and the other. My client wants to continue the normal schedule year round, not during the summer. To say that this is all, mom's behavior is all anxiety driven. No, she also has untreated bipolar and borderline personality disorder, but the only thing she treats it with is medical marijuana and therapy sessions. Those are not in and of itself enough to address those issues. If they were, we wouldn't have these other things. But the fact that she's not even talking with her primary care provider about her bipolar and borderline personality disorder indicates that she's not even taking care of herself. My client, as far as schools, offered Gull Lake or Kalamazoo schools as alternatives back before all of this was going on. To say that my client, mother has always responded. No, my client has unanswered questions. She may respond with something else, but as far as answering questions, no. She may respond to have an argument, but not necessarily to answer his questions. Serial City, to say that it's not an issue, but then to be mad at him for picking Serial City simply because his girlfriend uses it for her daughter, that makes it sound like now it's not an issue of, whether or not Demetrius is getting adequate care, but now is a matter of, well, I don't like that he picked that because of why he picked that location. And again, mother's testimony, or excuse me, the whole of mother's closing argument is centered around what mother wants, what mother needs, what she thinks should happen. But we need to be looking at this from Demetrius's point of view. And mother has not been making the unilateral decisions over and over and over. And so that needs to stop. And simply saying joint legal custody isn't going to stop that, because that's what parties have now under the temporary order. Thank you.
Thank you. Well, the court will note that it is now 4:33. There's no way the court can get through my ruling in this particular matter. So we'll adjourn today and then be back next Wednesday, April 10th at 1:30 p.m. And then the court will give its ruling at that time. Was legal custody and determination of the school. This case was heard over 4 days, which I will state is far longer than any case that I've ever had to hear with these limited issues. There was substantial, irrelevant, and extraneous evidence that was not germane to the issue the court had to decide. The parties did testify about numerous complaints that they had and have against each other, although the court would find that some of these were petty and insignificant. Court notes that if a party was not in litigation, these complaints would probably be innocuous and forgotten by the parties. However, because of the pending case, these complaints are used to bludgeon the other party and cast aspersion on each other. The court has considered all of the testimony. However, I will note that I'm giving greater weight to the most recent events over something that happened years ago. I would state to the parties so they know that credibility is always a consideration in every case. And oftentimes a party will allege that the other party or one of their witnesses is not truthful or is lying. The court has found, however, that inconsistencies in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of a witness's background, perception, bias, understanding or misunderstanding, or even mistake. When the inconsistencies occur, the court attempts to determine if they can be reconciled by other testimony or evidence. There was some conflicting testimony in this case, but not more than the court would normally expect to see. The court will and has assessed the credibility of the evidence and the witnesses in this case. Pursuant to MCL 722.26A, parties are to be advised of the joint custody, and the court will or shall consider joint custody. To determine whether joint custody is in the best interest of the child, the court should consider the following. Sub A, factors under subsection or section 3, which is the best interest of the child test, and whether the parties will be able to cooperate and generally agree concerning important decisions affecting the welfare of the child. Pursuant to the case of Daly versus Crownhammer at 291 Mishap 660, a 2011 case, the court must consider the general level of cooperation and agreement between the parties when considering joint custody. The question is whether the parties are generally able to cooperate on child rearing matters, not whether the parties necessarily get along. And that's Sherlock versus Richards at 273 Mishap 320, 2006. It appears that both of the parties love Demetrius and have his best interest at heart. They both appear committed to Demetrius' well-being, notwithstanding how they have dealt with each other. Although the parties have been more amiable than the court usually sees in cases. The court will now examine the best interest of the child test as set forth under MCL 722.23. When determining the best interest, as the court has stated, I have to go through, and I'm required by law to go through those particular factors. The first is the love, affection, and other emotional ties existing between the parties involved and the child. Court will note that Lindsay Potter, who was the owner of Bright Light Daycare, testified that Demetrius enjoyed seeing both parents. Dominic Milliman grew up with plaintiff's older son and lived with him for approximately 6 months. He testified that plaintiff and defendant have a loving relationship. I'm sorry, plaintiff and Demetrius have a loving relationship, and Demetrius snuggles up with plaintiff. He saw love and affection that between them, and noted that plaintiff was an amazing father. If Demetrius had nightmares, he would call for both of his parents. Demetrius was happy to see defendant. Defendant and Demetrius showed love and affection, and he believed that defendant and Demetrius were bonded. Zachary Ottinger, who had known the parties for 5 years, testified that plaintiff showed love, affection, that he would hug when he picked Demetrius, so when he picked him up, that defendant would do the same. Skylar Ward, who is plaintiff's son, testified that plaintiff would guide Demetrius when he had a tantrum. He would talk to him, he would calm him down. He felt that there was bonding between plaintiff and Demetrius, and felt that Demetrius loved both of his parents. Alicia Skurlock testified that Demetrius loves the plaintiff, hugs him, that Demetrius climbs all over the plaintiff. And we had a similar testimony that, again, Demetrius has a loving relationship with his mother. I don't find that this factor favors either of the parties, that they both demonstrate this. Next factor is the capacity and disposition of the parties involved to give the child love, affection, guidance, and continuation of the education of raising the child in his particular religion or creed. Court will note that this is, again, two things. It's capacity and disposition. The parties could have the capacity, but not the disposition. As stated under factor A, this factor does appear that both parties have exhibited and have the capacity and the disposition to provide Demetrius of love, affection, and guidance. Alicia Skurlock testified that Demetrius tells plaintiff about things that happen at school. They cuddle, and if Demetrius needs help, he goes to the plaintiff to get that. The court had noticed that there also was other testimony from defendant, her witnesses, that Demetrius has the same kind of relationship with her, and it does appear, based upon which I'll get in later when I talk about schooling, that each of them has continued the education of Demetrius in this matter. There's been very little testimony about religion in this case, or any religious involvement, so the court's not considering that. It does appear that this factor weighs equally as to both parties. Next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, and other remedial care recognized or permitted under the laws of this state in place of medical care and other material needs. Both parties have been provided the material needs for Demetrius when he is in their respective care. Plaintiff testified he does not believe that Demetrius is neglected while in the defendant's care, and defendant testified that she does not believe that Demetrius was abused or neglected while in the plaintiff's care. And both parties have been involved in taking Demetrius to medical appointments, as well as providing for his other material needs. As a result, the court will find that this factor does not favor either party as well. Next is the length of time that Demetrius has lived in a stable, satisfactory environment, the desirability of maintaining continuity. In this matter, it does appear, based upon the testimony of both parties, that they have a stable, satisfactory environment. And there's nothing that was testified to establish that they did not have a stable, satisfactory environment. Court would only note that believe that there was some testimony from the defendant that she might move in the future, but there was none. There was no set date coming up, etc. The court will find that this does not favor either party. Next factor is the permanency as a family unit of existing or proposed custodial homes. Court will note that plaintiff started dating Alicia Sturlock in 2022, moved in together in July of 2022, and it looks like, based upon the testimony, that they get along great. Testimony of the defendant was that she has a boyfriend now for about a year, but again, not residing together. And court will note that neither party testified as any issues in their relationship or any changes as upcoming in either of the homes. So the court will find that this factor does not favor either party. Next factor is the moral fitness of the parties involved. Again,
We just lost.
oh, we lost.
Sir?
We lost,
Yeah.
Ms. Ives.
We are back.
Okay,
Yeah,
Ms.
well,
Ives, where
definitely
did
a
you,
match.
where did we leave off when you got disconnected?
You were talking about the permanency of the family unit, that factor.
Okay. Well, as I stated at that point, just to reiterate, that plaintiff started dating Alicia Skurlock in 2022. They moved in together in July of 2022, and it appears that they have a great relationship. Court will note that the defendant testified she has a boyfriend of about a year. And a court will note that neither party testified whether there was a testimony that the relationships that they're in were any time volatile or would change in the near future. The court will find that this factor does not favor either party. Next factor is the moral fitness of the parties. There's been no testimony about either of the parties being unfit morally in this matter, so the court will not consider this factor in this case. Next factor is the mental or physical health of the parties involved. In this case, the plaintiff testified that he has no mental or physical health issues. Defendant has not raised any mental or physical health issues involving the plaintiff. Defendant testified that she has depression, anxiety, and has bipolar, and she has been seeing therapists for over a year. In this matter, the question is not what a person's condition is, but does that condition impede their care of the child? Zachary Ottinger testified that he had to pick up the defendant after an accident with a deer. She was emotional, crying, seemed to be dancing around, as he said, her stating ending her life, but she calmed down over the 40-minute drive and exhibited no self-harm during that time, nor had he seen any since that October situation. On October 15, 2022, Demetrius had a soccer game while in plaintiff's care. Demetrius was sick and the weather was not good, so plaintiff kept him at home. The defendant went to the game, and when plaintiff and defendant or Demetrius were not there, she called plaintiff multiple times, but plaintiff did not have his phone with him, and she left a message then that he better answer or he'd get his door kicked in. Plaintiff said that she couldn't reach plaintiff for about 45 minutes. She was anxious and stressed, and she acknowledged that her conduct was wrong and apologized. Another time when she couldn't reach plaintiff, she threatened to come knocking on doors, and the court finds that her actions in response to these incidences were irrational, excessive, and totally inappropriate. It's one thing if, in fact, the child is gone someplace and you have this, if the child is with friends or child's out playing and all of a sudden disappears for that period of time, that would be appropriate. The court doesn't believe it's appropriate when the parent is with a child or when the child is with a parent in any of that. Another incident occurred on 10/17/2022 where defendant told plaintiff to drop Demetrius off at a hotel where she was staying. When plaintiff questioned her as why she was staying at a hotel, she said that it was none of his business. Defendant said she needed Demetrius because she was on the edge. It turns out that now we find that she was in the hotel because her house was being bombed for fleas. It does appear to the court that plaintiff's mental health issues do impede her ability to properly care for Demetrius, and as a result, the court will find that this factor favors the plaintiff. Next factor is the homeschooling community record of the child. Court notes that Bobby Van Werner, she was Demetrius's teacher at Dudley. She testified that both parents came to the open house, both were involved in school, they go to the conferences, and both parents cooperate on issues in this matter. She testified that Demetrius he turns in his homework, he's a smart student in math, reading, and spelling, and she has him working on first grade mental math. She did not testify there were any issues about him missing much schooling, no behavioral problems. He was respectful. The only problem he had was had some issues paying attention. Lindsay Potter, the owner of Bright Light Daycare, testified that the defendant enrolled Demetrius in that daycare. However, both parties were involved, and the only problem was Demetrius had gotten a number of abrasions, bruises that she attributes to or believes that decreased once he had in fact received glasses. There was one issue that arose at that time when the plaintiff was removed from the defendant's account. However, that was rectified when plaintiff got his own account. Ms. Warner, who heads the 21st Century program, which is a before and after school program, testified that Demetrius is great at math. He has no discipline issues, no social skill deficiencies, and she has had limited contact with plaintiff, and he was pleasant, but he didn't appear to be interested in the program. The court will find that, again, this factor does not favor either parent in this case. Next factor is the reasonable preference of the child. In this matter, the court did interview the child and will consider that his preference is a factor in this case. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the child and the other parent. Plaintiff testified that defendant when she does not get her way, she has threatened to keep Demetrius and did so over Christmas of 2022 and early 2023. The court will, however, note that there was no parenting time order in effect during this time, and the testimony shows that both parties have been somewhat flexible when they need to have a change in parenting.
We lost, Your Honor, we lost Ms. Ives again.
Okay. Thank you for saying that. Going through my notes, I can't watch the screen too.
No problem. Is it possible to ask on what date the child was interviewed, Your Honor?
I don't recall the date.
That's okay, never mind.
Spectrum is having issues apparently. We last heard that the last thing you said that there was no parenting time order after talking about the Christmas break.
Okay. Court will note that based upon the testimony that both of the parties to appear to be flexible and allowing time to the other party when something comes up or they need Demetrius with them. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the child. The court will note that the defendant testified that on one occasion, the plaintiff was yelling at her and backed her up against the wall. And she, however, acknowledged that plaintiff never laid a hand on her. Mr. Ottinger testified that he did not see the parties fight. And Skylar Ward, the plaintiff's son, testified that he did not see the parties have any heated interactions and no physical aggression by either party. Although he did on occasion, he said he had heard defendant screaming and throwing things in a room that he was not at. Plaintiff
Did you,
Well,
I was gonna say, did you cut out there or was there a pause?
No,
I'm sorry.
no,
I
a
thought it was
pause.
my internet.
I think my notes were incorrect. I want to correct those. Defendant's complaints in this matter appear to be her reading too much into what the plaintiff says. As she testified, it was the tone of the plaintiff's communication. And I will state the court addresses facts, not what a party feels about what is said. The issue is what was actually done, not what their reaction was to it, or whether they felt in this matter the tone of it or something of that nature. The court will find that this factor does not favor either of the parties. Any other relevant factors considered by the court doesn't believe that there really was any other relevant factors that stood out to the court. I want to address in this matter the areas where the parties have had disputes and agreements. First, an agreement, the defendant took it upon herself to get glasses for Demetrius. Plaintiff initially didn't think that it was necessary and wanted a second opinion. He took Demetrius to another doctor and the prescription was ultimately changed. However, the parties didn't argue about it. They didn't fight. They just had a different opinion. And with both of their input, the matter was satisfactorily resolved. Plaintiff changed Demetrius' doctor from Gray's Health to Cereal City Pediatrics because it took too long to get an appointment, and the defendant did not oppose this. Plaintiff also took Demetrius to another dentist, Highland Dentistry, and defendant did not oppose this. The parties did discuss and agree that they would not employ corporal punishment with Demetrius. And plaintiff testified that communication with defendant is sometimes good and sometimes non-existent. Parties had minor disagreement about haircuts for Demetrius, and it ended up with them agreeing or acceding to the fact that plaintiff would take care of the haircuts. Defendant testified that sometimes the communication with plaintiff is rocky. And again, she said she feels again that he's condescending and then she would get snippy back. Again, of course, not concerned about your feelings, ma'am, concerned about what actually happens. Defendant testified she is willing to make changes to address any issues that they have. And she believed that face-to-face communication was best. Alicia Gerlach also testified that the parties do communicate well in person. Defendant initially enrolled Demetrius in Brightline Daycare, and plaintiff said that he did not have any advance notice, but defendant testified that plaintiff eventually told her to just go ahead. When the parties have to discipline Demetrius and take away his phone or other privileges, they've agreed that they will enforce that punishment while Demetrius is in each of their homes. Defendant enrolled Demetrius in Dudley School because they missed the enrollment in Fremont, and they did not have any agreement as to where he would be enrolled. Plaintiff enrolled Demetrius in Montessori school without consulting plaintiff. Court will note that both parties have taken unilateral action without consulting the other party, but most of the time, the other party has acceded to the actions taken in this particular case. And it appears that both parties have, again, Demetrius's best interest in heart and are able to do what is best for him. Court believes that it is in the best interest of Demetrius that both parties are involved in making decisions for him. And as a result, the court will award the parties joint legal custody. I have found that, except in rare occasions, once a case has concluded, the parties are better able to communicate and make decisions for their child. Now that I have awarded joint legal custody to each of you, I will note and tell you that as you communicate, if you are unable to agree, don't get upset, don't have argument or conflict, simply bring the matter back before the court, and the court will decide the particular issue. Now the court will turn to the issue of schooling. The plaintiff wants Demetrius in the Montessori school. Defendant wants Demetrius in the Battle Creek Public Schools, and he has attended kindergarten in Dudley School because she missed the enrollment in Fremont. Demetrius also attends Montessori while in the plaintiff's care. Martha Hosick, who is the secretary of Battle Creek Public Schools, and defendant testified that if Demetrius remains in Battle Creek Public Schools from kindergarten through graduation, he's entitled to take advantage of the Bearcat Advantage, which provides for 100% paid college tuition at any college in Michigan or any NAACP college in the country. David Averill, the principal at the Montessori, testified that the Montessori goes from grade kindergarten to 8th, and that they have no organized sports program, and they have smaller class sizes of approximately 20 students. Plaintiffs testified that he is looking into whether, as a Native American, and he states possibly Cherokee, he would qualify for any programs through the tribe, but nothing has been confirmed, and it's only speculative at this time as to whether he qualifies for enrollment and whether there is any program available. Demetrius appears to be a gifted, intelligent student, excelling in school and advancing in math and reading, which was testified by Ms. Warner and Ms. Van Warmer. And the court believes that there is substantial benefit to the parents and to Demetrius to have guaranteed college tuition, which is paid for in this matter. The court does believe that, based upon all of the testimony, that Demetrius should continue in the Battle Creek Public Schools. Court will note that it is preferred that he would attend Fremont over Dudley. Court has had many cases involving Fremont School and Dudley School, and court finds that the Fremont School is preferable to Dudley, which is, again, an underperforming school in the Battle Creek School District. Court will next turn to parenting time. It is presumed in the statute that it is in the best interest of the child to have a strong relationship with both parents. Pursuant to MCL 722.27A1, parenting time shall be granted in accordance with the best interest of the child after examination of various factors, which the court will go through at this time. Factors that the court has to look at is whether there's any special circumstances or needs of the child. The court will find that Demetrius does not have any special circumstances or needs. Next factor is whether the child is under 1. He's not, and so that's not applicable. Next factor is the likelihood of abuse or neglect of a child during parenting time. As stated previously under the other factors, no party has testified that there's a likelihood of abuse or neglect of a child during parenting time. Court will find as well that there is no likelihood of abuse of a parent during the exercise of parenting time. Next factor is the inconvenience or burdensome impact of travel on the child. Parties are within a close proximity to each other, so there's not any excessive travel in this matter. Next factor is whether a parent reasonably expected to exercise ordered parenting time. In this matter, it does appear that both parties have exercised and taken advantage of all their ordered parenting time. And the next factor is whether a parent frequently failed to exercise parenting time. Court will not find that they have either of the parties that failed to exercise parenting time. In fact, have wanted more parenting time. Next is threatened or actual detention of the child, other than the Christmas 2022. The court notes that there was no threatened detention of the child in this matter, and the court again notes that that occurred when there was no parenting time order in place. Court will note in this matter that the parties are free to and encouraged to be flexible and change parenting time as it may be necessary. However, the court would caution that if there is a change in parenting time, the court would recommend that you put it in writing. And the court will first grant the parties parenting time at all times and places to which the party may mutually agree. And if they can agree, the court will note that the parties have been following the parenting time schedule delineated in the temporary order preserving the status quo entered on October 17, 2023, which provides that the defendant will have Sunday through Tuesday and alternating Wednesdays. Plaintiff will have Thursday through Saturday and alternating Wednesdays. And the party's holiday parenting time was spelled out in the order of November 28, 2023. Both of these schedules have been working satisfactorily, and the court will continue parenting time as continued or provided for in both of these orders. There was some question or confusion as to the start times of parenting time, which was not addressed in these orders. So the court will order that the start time will be 6:00 p.m. The court further ordered that the parties shall, the court further orders that the parties shall receive 1/2 of the summer vacation period in alternating weeks from Friday at 6:00 p.m. through the following Friday at 6:00 p.m. They shall have 1/2 of the Christmas vacation period, with plaintiff to receive the first half during 2024 and each alternating year thereafter, and alternating spring break, with plaintiff receiving spring break 2025 and each alternating year thereafter. The court will not, in this matter, grant a right of first refusal as requested. Court finds that this creates a quagmire, which is fraught with potential conflict and problems, and so the court will not order that in this particular case. Court further order that the plaintiff will continue to receive the after-school periods when Demetrius is in defendant's custody, as provided for in the temporary order when she is working. Court will order that the plaintiff is prohibited from removing from Demetrius from school early. Court needs to address child support. Was testimony by Stephanie Garcia, who is the plaintiff's HR manager, and she testified that plaintiff makes $27.81 per hour for full-time. He does not receive any bonuses. He gets some overtime, but that's only if he's called in, and there's no pattern to that, so the court will not consider that in this matter. Court will note that the plaintiff pays sum of $121.42 per month for insurance, which includes Demetrius, and as a result, the court will order that he is entitled to a deduction for the amount of this insurance premium attributable to Demetrius. The defendant works at Dudes in Coldwater, and she makes $17 an hour. She also works at the Vegas Strip. Oops. We
Yep,
lost
we
you.
lost.
Okay,
Sorry, Your Honor, the last thing you said was the defendant works at the Dude.
okay. She works at Dudes, makes $17 an hour, works at the Vegas Strip Thursdays and Fridays as a DJ, where she makes $10 an hour. And she testified that her yearly income is $17,700. She also testified that she makes between $50 and $60 per weekend in tips. And so the court will average this out at $55 for 52 weeks, which totals $2,860. Adding this year to her yearly income brings her total to $20,560. The court will use those amounts for purposes of calculating the support in this matter. The court will therefore direct Ms. Storm that you would prepare the appropriate judgment in this matter. And the court will direct the attorneys that you can pick up your exhibits if you want within 10 days of today's date, or if you fail to pick them up within that time, the court will have those destroyed. Ms. Storm, is there anything you believe that the court has not addressed or that I need to address before we conclude?
Tax exemptions for the parties for the purpose of child support calculations, Your Honor? Should they be alternating?
The court will alternate those. I don't know if Ms. Storm, can you tell me it did, I'll ask Ms.
My client's never claimed the
What?
child. My client's never had the opportunity to
Okay.
claim the child.
Okay, as a result, the court will order.
Your Honor,
that
my
he get-
client,
Go ahead.
oh, my client is okay with alternating the years. She had already claimed Demetrius for 2023.
Okay, the court will order that the plaintiff is entitled to the tax exemption for 2024 for all tax purposes and each alternating year thereafter. With that, Ms. Storm, anything else that the court has failed to address or needs to address before we conclude?
Nothing is coming to mind, but let me just check with my client. No, there's nothing
Your
further.
Honor,
Thank you.
Okay, Ms. Ives, is there anything you believe that the court has not addressed or needs to address before we conclude?
My client was wondering if the court would make any ruling on the 21st century before and after school program.
That is not a schooling. The court will not order that occur. So if in fact she wants to have the child in that program, during time she has the child, she can do it, but I'm not going to order that the plaintiff be required to do so.
Your Honor, that interferes with your order that my client be able to take care of Demetrius after school on Monday, Tuesdays, and alternating Wednesdays.
Oh, okay. Well, it does. Well, the intent is that he would have the child when the child is not in her care. So again, if being the fact that the child has to be in that program on the Monday, Tuesday, and alternating Wednesdays, the court would order that, again, he gets that time with the child and that she then would not enroll the child, but she has a right to enroll him in the morning program on those particular days.
Okay, so morning program, okay, but afternoon program is not,
Right.
just so that I'm clear. Okay.
Correct. Anything else, Ms. Ives?
I just want to clarify that if my client is out of work when the child gets out of school, she has that time, correct?
That is
It's only
correct.
if she is working, correct?
That is correct, and she will be required to
Okay.
notify the plaintiff if she is not working those particular times, and court will order that she gives him at least 8 hours prior notice. If she doesn't give him 8 hours prior notice, then he still gets to keep Demetrius during that time. You include that as well, Ms. Storm.
I will. Is there any requirement to share schedule?
Well, court would hope that they would do that, but obviously schedules change, so I'm not gonna order it, but it seems like that they would be able to resolve a lot of potential disputes if they exchange schedules, so.
I'll put that language that it's, I'll basically indicate that, but that you're not specifically ordering it, but that it's encouraged.
Okay, thank you. Anything else, Ms. Storm?
I
You
believe
went-
that's it. Thank you.
Okay, Ms. Ives, anything else?
No, Your Honor.
Okay, thank
Oh,
you
Your Honor,
all.
one more thing.
Okay, there is, okay.
Your Honor, one more thing. My client in her relief had asked for a weekend that would allow the parties to give makeup parenting time. Is there a way the court would fashion?
No,
at
I'm not,
least,
I know you asked for that.
that
I didn't address that because I was not going to order that, and with the fact that the court has in fact, now ordered and provided for summer parenting time, she'll be entitled to have a number of weekends in the summer. So I'm not ordering it at this point.
Okay, thank you.
Okay, thank you all. I hope everything works out for you. I think that you've done an excellent job with Demetrius, and you're so far ahead of a lot of other parents in that the issues may seem substantial and insurmountable to you, but quite frankly, based upon what I see, they're very minimal. So I hope everything works out. You're free to go. Have a great day.
Thank you. Have a good day.
Thank you, sir.